that judgment.
Mr. Khalid?
Maybe not with the principle, but the way it has been expounded, I'm not very comfortable using that as a precedent.
Mr. Khalid, the provision is similar in Indian Constitution and Pakistan.
The language of Article
reference.
143 of Indian Supreme Court leaves some discretion to the court. In our case, it's more in the
Shall.
Indeed, yes. Indeed.
Well, I think Mr. Makhdoom Ali Khan has made a table comparing the difference.
Bilkul. Hamara earlier provisions were different.
So here, whether we like it or not, we have to answer the question.
unless the political questions or social
But that is also answering the question.
Indeed.
You can't leave it unattended. You have to say whatever you have to say.
Indeed. In fact, in the Senate election, my Lord Mr. Justice Yahya Afridi was not in agreement with the majority, but he answered in a different manner. So,
ठीक है, आगे बढ़ते हैं. Do you have any other precedent other than this Indian one?
so precedent revisiting the judgment directly from subcontinent, at least I couldn't find. This was the only case where
Anywhere in the world.
the jurisdiction, like US doesn't have this jurisdiction.
We were looking at Islamic jurisprudence on this.
I'm not qualified
In the
to.
morning we were dealing with Islamic provisions, but here also I want to look at Islamic provisions, but nobody comes and helps us.
Perhaps scholars who are more proficient. I'm certainly not one of them. I'm not qualified to enter into that area.
So, as I understand, the only way to approach a precedent of the court is to look at it from a distance, whether the process was correctly followed or not. Because we can't go into the merits of the case.
That is my view.
So process would actually mean that the judges themselves did not follow due process, or they were biased or something to that effect.
And the
That's
overall
what you
environment.
mean by procedural impropriety.
Well, more than that, Your Lordship would recall on the last date, my Lord, the Honorable Chief Justice, it's not just the particular bias of judges. The whole society, it was, Your Lordships have held that one-man rule is not good. Now, one-man rule, the country was under one-man rule, who was absolutely interested in eliminating one man who happened to be the accused in this case. So that context perhaps would be, in rarest of rare cases, this would happen again, where other than bias and improper trial, the military
He
regime.
may be interested not only, but it could then come down to either you or me.
Indeed.
May the Article 6 may come in.
Indeed.
Probably you can relate it to Oliver Cromwell. It can be either one or the other. Both cannot survive.
And anecdotally, it is said that it's one grave, either you or me, either Zia or Zulfikar Ali Bhutto. So General Zia had the entire state machinery at his disposal. And when I take your lordships to the judgment of Supreme Court, sir, 78 paragraphs were written by Supreme Court to justify the bias of Lahore High Court. Where in the world would you need 78 paragraphs on 24 pages of Supreme Court judgment
Which
to say
one are
that
you talking about?
Zulfikar Ali Bhutto's judgment in Supreme Court, I'll take your lordships. It enumerates the allegations of bias. So it took Supreme Court 78 paragraphs
To say there was no
to
bias.
say that there was no bias. What more evidence of bias does one need?
I also think, if
74 paragraphs.
I also think, if I'm not wrong, that this judgment is the longest criminal judgment in Pakistan's history. Is that so? It's 900 and something paragraphs.
indeed.
How many paragraphs is it? Do you have it before you?
Yes, sir, I have, sir.
Because I've never read such a long criminal law judgment.
So it starts from page
No,
53.
just see the last paragraph. How many paragraphs? I think it's 900 and something. So because civil constitutional matters do go into such details, but criminal matters.
Yes.
I think it was 953 if I recollect. Anyways,
935.
935. Now who's the best criminal lawyer in the courtroom? 935? 935. तो इससे ज्यादा कोई लंबा जजमेंट हुआ है क्रिमिनल लॉ में या ये दिस होल्ड्स द रिकॉर्ड?
सिर्फ बायस पे आप देखिए
नहीं,
पैराग्राफ.
मगर ये इतना लंबा क्रिमिनल लॉ का जजमेंट, क्योंकि आमतौर पे गिल्ट यू हैव टू एक्विट और कन्विक्ट, मतलब यू जस्ट कंसीडर द एविडेंस एटसेट्रा.
इससे तो ये लग रहा है कि वो खुद भी कन्विंस नहीं थे इतने ज्यादा डिटेल देने को.
एग्जैक्टली. इन कैमरा ट्रायल पे सर उन्होंने लिखे हैं पैराग्राफ्स जो इन कैमरा ट्रायल पे सुप्रीम कोर्ट ने 171 पेजेस 33 पैराग्राफ्स इन कैमरा ट्रायल को जस्टिफाई करने पे लिखे.
It reminds me of a case in the House of Lords where it said we have a good prima facie case. The lawyer went on for about half an hour. He said if you had a good prima facie case, I guess you would take half an hour with it.
Indeed.
So, okay, I don't know whether anything builds on that.
So when your lordships will go to the details, a paragraph from Lahore High Court where the learned judge said Mr. Zulfikar Ali Bhutto is not a good Muslim. Now what has that got to do with the criminal trial? And the Supreme Court justifies that he should not have said, but so what?
Khan Sahab, dekhiye.
Who said that?
Mr. Justice Aftab in Lahore High Court.
Said that?
And this, yes, sir.
दिखाएं वो कहाँ है?
So ये है page PLD.
I don't remember that.
PLD 78, Lahore, page 53.
Approach.
At 663. Paragraph 609.
At 663.
663 पे Lahore High Court, para 609. And Supreme Court found nothing wrong with it.
Paragraph कौन सा पढ़ने?
So मैं 609 अगर पढ़ लूं, at page 663, the principal accused is the arch culprit having a motive in the matter. He has used the members of Federal Security Force for personal vendetta and for the satisfaction of an urge in him to avenge himself upon a person whom he considered his enemy. For his own personal ends, he has turned those persons into criminals and hired assassins and thus corrupted them. Indeed, it is paradoxical that the ruler of a country with Islam constitutionally declared as its state religion, enabling the Muslims to order their lives in the individual and collective spheres in accordance with the teaching of Islam as set out in the Holy Quran and Sunnah, and its declared objective, the guaranteeing of the citizens their life and liberty, should play with their valuable life of a citizen so whimsically and tyrannically. The Constitution provision presupposes that before a person ventures to seek election to the office of the Chief Executive of the Federation, he would order his own life in accordance with the injunctions and teachings of Holy Quran and Sunnah. Before undertaking to observe the principle of democracy...
This is the main criminal trial.
This is the main judgment of the Lahore High Court. So before undertaking to observe the principles of democracy, freedom, equality, tolerance and social justice as enunciated by Islam, he should inculcate these qualities in himself.
Are you trying to build the case that the mere such expression finding place in a criminal trial judgment itself constitutes bias? Is that your point?
Indeed, but
Or is some other point you're making?
this is the focus, this is the thrust of the submission, sir.
And how was this paragraph considered by the Supreme Court?
It was considered by the Supreme
And how
Court.
was it sustained or repelled?
So, the particular para I'll point out. Para 910.
Observation नहीं देनी चाहिए. I find it very strange in a criminal case.
And it was totally
910.
unnecessary.
I mean, 9 and 10.
PLD 79, Supreme Court, page 53, Supreme Court judgment, para 910.
अब सुप्रीम कोर्ट का भी मुझे इनायत कर दें. ये 2000 PLD कौन सा है?
The PLD 79, Supreme Court, starts with 53. At page 384.
अब छोटा ऑर्डर कौन सा इसमें दो है ना? डिटेल
Detail.
जी.
जो 53 से शुरू होता है.
Page 384.
Page 53 से शुरू होता है.
नहीं, आप कहाँ से पढ़ना चाहते हैं?
384 से.
पढ़िए.
Paragraph, last paragraph 910.
पढ़िए.
In paragraph 610 to 16 of the impugned judgment of the High Court has made gratuitous observations about the personal belief of the appellant and delivered a sermon as to the mode of conduct prescribed by Islam of a Muslim ruler. It is also stated that the appellant was a Muslim in name only and that he had abused his powers under the Constitution. I am inclined to agree with the learned counsel that the observations in these paragraphs were not necessary for the disposal by the High Court. In this connection, however, the learned counsel further submitted that these observations and remarks about the appellant disclose the extreme hostility and bias entertained on part of the learned trial bench against the appellant. It, however, appears to me that the High Court had found the appellant guilty along with other co-accused on the merits of the evidence adduced in the case. Its findings to that effect were not influenced by any such extraneous consideration. In fact, it was only towards the end of the judgment that this discussion occurs, and the conclusion was drawn in proposing the punishment as stated in paragraph 617 that the appellant was thus liable to deterrent punishment. Although even for this limited purpose, also these observations were not strictly relevant, yet they did not thereby vitiate the order of conviction of the appellant, which was not based on any such extraneous considerations. Now, I can't think of any one of your lordships today writing this paragraph in this particular context.
I need to understand from you, Mr. Khalid Khan, is the court might have given bad judgments, wrong judgments over the years. Then the facility of review was available. So this particular statement that you refer was available, and review could have been filed against that. As I understood from what Mr. Makhdoom said, that when we're looking at this jurisdiction, the one that we're talking about, you're looking at the case in a totally different perspective. You're not looking at the merits, you're not looking at what happened, because that was already settled. You had all the grounds available. You could have raised it in review and settled it. Like this, every bad judgment and every wrong judgment would be open in this case. So it is whether at all there was due process, and that would mean whether at all the judges were independent enough to decide this matter. So this matter was properly adjudicated and fair trial was granted. So all, as I see it, you have to establish before us that either all or one judge was not independent. And that led to a mistrial kind of a argument. But and if you could refer to the material available to establish that the judge was not independent. I mean, I don't understand any other argument. There is no other way that you could say his judgment is wrong unless you show that the bench itself at that time could not possibly have adjudicated the matter fairly without bias. And you'll have to show some material, because it's a big, tall order. You're telling the Supreme Court of Pakistan that they were under pressure and they were deciding a matter which was something that they were under pressure and they could not independently decide the matter. You have to show me that material. Because otherwise we keep on opening everything.
I've addressed this
Khan Sahab, if I, in a way, it may be responding to my learned friend with respect, but one of the due process requirements is, inbuilt in every due process requirement, is that a judge must be free from bias. Now, I think what you are showing to us is this: forget the material that I may show before you. These are judges talking themselves, writing themselves. Are they demonstrating bias or not? Probably that's what you're saying. The other question of pressure is a separate question altogether.
Indeed.
So due process, that may be an additional ground. So the question before us is, do these words in themselves, these are not words, what I've said subsequently in a judgment or in a book or something like that, I may have forgotten what I've said, but this is what I'm saying in the judgment. Does this demonstrate bias or not? Probably that's it. And if it demonstrates bias, then the due process fair trial requirement may be vitiated or undermined or absolutely done away with. I don't know. So sorry, with respect to my learned colleagues.
So adding to that, I mean, if there are two grounds now, one is that there is a pressure on the bench, that's totally extraneous to the case, that's one. The other is that the bench, the judges themselves are biased. Now, first of all, that bias issue was taken up in review and must have been sorted out. But still, if you think while deciding the review there was bias, you must have some independent evidence today to establish that there was bias. Because like this, every case could be opened up on the ground
That's
of
very
bias.
fair. But
Review में ये touch हुआ था? Review में did they touch upon this?
The Supreme Court review was very limited. But
No, was this aspect, as my learned colleague has pointed out? Huh?
Supreme Court was
In review was it touched
That
upon?
was available to you. You
review
could have
tha
said
unanimous.
that ground was available to you. You said they were biased, but that ground was not taken.
So I'll explain. The judgment of Supreme Court, detailed judgment, addresses all those questions. Now, the review was on a very limited ground, but two submissions. First, as my lord observed, if your lordship will recall, in Asif Ali Zardari case, only one judge was found to be influenced. In Pinisha case, only one judge of the House of Lords was found to be affiliated. That led to annulment of entire judgment. But most interesting, if I may tell your lordships, more grounds that judges were not independent or independently appointed. Majority of them were ad hoc judges who had Mr. Bhutto.
We'll come to them separately.
Khalid, what were the grounds of review then?
Sir, वो तो बड़े limited ground पे था.
क्या limited ground?
On the merits of the case, not all these.
मेरिट अब 22 का ग्राउंड आपको अवेलेबल तो था ना 22 का ग्राउंड जब
bias का ground तो है ना. It's a merits.
They didn't seek
Sir Khalid
review.
Javed, can I come to your rescue?
As always.
Arguing a review before the same bench and saying you are biased would be pretty, maybe not appropriate because then you
No,
are
that's a
limited
legal
relief.
ground. That's a legal ground. You could take it.
Let's hear these.
Ground
we
to
are
take
talking
and-
about the bias of the Lahore High Court that you can take before the Supreme Court in review कि आपने वो जो bias Lahore High Court का था वो आपने सही तरह
तो
नहीं
वो
देखा
सुप्रीम
उसको
कोर्ट ने
देखें।
लिया जो मैंने 78, 74 पैराग्राफ्स पढ़े वो सुप्रीम कोर्ट के हैं.
एरर हो सकती थी ना उसमें भी
Sir,
मतलब
अगर वो हो सकता था, Mr. Bhutto would have been alive if the court was that independent. But मैं एक और ground ले रहा हूँ.
Khalsa Vexen सुन ले, but we are approaching this, and I'm all open for this, that if there is miscarriage of justice, that needs to be rectified. That's the broad principle. The question is how to approach the issue. That's very important. We are all for this, that miscarriage of justice, something needs to be done about miscarriage of justice. I can't live with a history which has miscarriage of justice. Fair enough. The question next is, in this particular case, what could you take us through the evidence material which would show me that this miscarriage was equal to the judge not being independent? Let's deal with that first and then go on to something. I mean, please identify that this particular judge was not independent. I would go along with you.
First, let's go to the constitution of the benches.
ठीक है.
Paragraph 10 of my submissions, I have addressed this issue.
Ji.
If I may go to para 10D, if you may skip ABC. Supreme Court, I'm narrating the factual background. The appeal was initially heard by 9 judges of Supreme Court from 1st April 78 till 30th July 1978. But on that date, Justice Qaisar Khan retired, who could have but was not appointed as ad hoc judge to continue till conclusion of the appeal. Thereafter, 8 judges heard the appeal, but on 20th November 78, Justice Wahiduddin Ahmed fell ill, leaving 7 judges to decide the appeal. 2 of the judges comprising the majority of 4 were ad hoc acting judges of Supreme Court. Justice Karam Ilahi Chauhan was acting judge between 27th July 1978 till 13th June 1979. Mr. Bhutto was executed on 4th April 1979.
Before you proceed further,
Sir, only after dismissal of Mr. Bhutto's appeal, he was appointed a judge of Supreme Court.
नहीं वो बात की बात है ना मगर पैराग्राफ डी में आपने 4 महीने this appeal lasted 4 months.
नहीं सर, 1 साल 4 में, अगला 79 है.
Read it again. The appeal was initially heard by 9 judges of the Supreme Court from 1/4/78 till 30/7/78.
79.
ना आपने 78 लिखा है.
30 June 79.
नहीं आपका मैं पढ़ रहा हूँ. You're not reading it yourself correctly. Read what you have written. Paragraph 10D पढ़िए. Paragraph D में पढ़ रहा था. So it was heard for 4 months.
Sir, my apology, वो typing mistake है. 79 है. मैं जो जिससे पढ़ रहा हूँ उसमें 79 मैंने ठीक कर लिया था.
1 year and 4 months that criminal appeal was heard.
Yes, sir.
Yeah, are you sure on this?
So I'll recheck again.
ये देखें
I'm just talking about the time spent in hearing a criminal. Is this another record? Because I've never heard of a criminal appeal lasting so long.
So ये अगर पेज जिस आपने बताया पेज 53 XX पे है, डेट्स लिखी हुई है सारी.
So just first date कौन सी और last date कौन सी?
Date of hearing 1st and 15th April, and this goes on till 23rd December 1978.
23rd December 1978. So
लेकिन वो तो फाइनल
इतनी डेट्स पे हेयरिंग हुई अपील की.
सर ये सारी उस पर डेट्स पूरी लिखी हुई है.
9 जजेस का जो कहा इसे जरा कंफर्म कीजिए. आपने कहा ना 9 जजेस हेयरिंग स्टार्ट हुई, वो डेट्स आपने ये दिए हैं, फिर एक जज रिटायर हो गए, एक जज बीमार हो गए.
जी सर.
वो तो बाद की डेट्स है ना.
सर ड्यूरिंग ट्रायल एक रिटायर हुए, एक बीमार हुए. It started with a 9-member bench, and
of the appeal.
During the proceedings.
नहीं देखिए, now comes maybe, I'm just raising a question. Is this impropriety when the case starts with a particular bench, फिर उसकी reconstitution हुई या नहीं हुई? Because I don't know.
So
do you have the answer to this or not?
जी इसमें है सर. उसमें इस तरह वो जस्टिस कैसर खान retired.
He can retire, but he can be substituted by another 9-member bench.
That is what
But you
my
said it
suggestion
fell short of 9 members. It went down to 7.
7. One fell ill.
Why would they not replace by others? Because from my perspective, an ad hoc judge, a normal judge is equal. Agar if we start making this distinction, then it's another can of worms. Let's leave that aside.
So उनके tenure execution की फौरन बाद उनको confirm judge
वो एक अलग point है. ठीक है, but I'm just saying कि how did 9 become 7?
In the recent,
Either you start with 7, fine, you can start with 3 even.
in the recent past, we started with 9 and ended up with 6. Was it an election matter?
Well, there is an explanation for that, but here
of judges at that time 9
Supreme Court की.
yes.
Because I think we'll have to see the original file of the Supreme Court to see how were the benches reconstituted. Because this probably will not be mentioned in the judgment unless it is.
तो उसमें judgment में
Because
लिखा है.
like for instance, how many we are today? 9, right? I don't want the case to be dragged on, but one of us will be retiring soon. So does it become an 8-member bench, or should we substitute him with another 9-member? Ordinarily, one keeps the same strength of the
Mr.
bench.
Mansoor, could you tell us about this?
The total strength of the Supreme Court was 9.
Yes.
One judge who retired, new appointment was not made, the other judge fell ill, so the remaining 7 then...
नहीं, उस जमाने में क्या total sanction strength थी 9 की?
Not थे total. एक बीमार हो गए, एक रिटायर हो गए, जो बाकी remainder...
इसमें 2 तरीके हो सकते हैं ना, या तो
उनमें ad hoc judges भी थे.
जी सर ad hoc थे. नसीम हसन शाह साहब ad hoc judge.
वो कैसे हो सकते थे जब स्ट्रेंथ ओरिजिनल स्ट्रेंथ कंप्लीट
पूरी नहीं थी?
फिल अप करके फिर आप एड हॉक अपॉइंट करते हैं ना.
पूरे थे उस वक्त, वो अपॉइंट हो रहे थे, मार्शल लॉ लगा हुआ था.
नहीं, देखिए ये असली बात आ गई ना. अगर तो जैसे what the learned attorney general has pointed out, if ad hoc judges can only be appointed, the constitution I don't think has undergone a change in this, that once the Supreme Court is full, then you add on. If the Supreme Court had 2 vacancies, then ad hoc could not have heard the matter.
ये बाद में अमेंडमेंट तो नहीं हुई आइन में, ये कि पहले आप स्ट्रेंथ पूरी भरे फिर एड हॉक
It is unamended.
73 का दिखाएं ओरिजिनल आइन जो है गुलाबी वाला.
देखते होगा उस वक्त मार्शल लॉ अंडर सस्पेंशन, कॉन्स्टिट्यूशन अंडर सस्पेंशन था, मार्शल लॉ में.
Let's not use this terminology. Let's not use this terminology. Let's not use this
So
terminology.
there are 2 choices. You could either replace a judge and have the same strength of the bench, or you could have a smaller bench. That's exactly what happened recently in the 9-member bench that ended up with 6 or 5, whatever. 5.
My lord, seeker indulgence on this very issue. My lord, when Justice Wahiduddin took sick.
No, I'm asking a different question.
No, my lord, I'm coming to that.
Okay.
Your lordship's essential query was that how did the 7-member bench continue to hear the matter when originally there were 9? When Justice Wahiduddin took sick, this matter was taken up in court, and in PLD 1979, Supreme Court 38, in that judgment, the court itself said that we started off with 9, but he has fallen sick, and therefore the 7-member bench will continue to hear the matter.
Okay.
So that is.
Then how did the ad hoc judges come in who were appointed? The next question is the Constitution.
My lord, there was one ad hoc judge who was there in the original 9-member bench who subsequently retired.
Who was the ad hoc judge?
That was
Dr. Nasir Shah continued. Justice Karamilahi Chauhan was acting.
And I'm really confused.
Kaisar Khan was an ad hoc judge, my lord, and then he reached the age of superannuation.
No. I think there's a missing link still. I really want to know, was the sanction strength of the Supreme Court at that time 9?
Yeah, 9, my lord.
Okay. Now the question is, when the strength falls below 9, how can an ad hoc judge be appointed till first the whatever number of vacancies are filled to bring the number up to 9, and then you appoint ad hoc? That's the present position in the Constitution. Was it different then?
No.
Let's look at the Constitution then.
It wasn't different at that time.
182.
रोजा दें उनको भी किताब. Now, I think the position was slightly different then.
We are going more into the merits of the case. What were the questions formulated, legal question, for the disposal of the reference, presidential
I'm not
reference?
discussing merit at all. I'm only discussing the complexion of the court and what was influencing, or if there was any bias, irrespective of merits of the case. I would not go into the merits of the case at all.
उसकी बेसिस पे आप उसको विशेष तो नहीं कर सकते.
Okay, maybe we come to this later after we've consulted it. Ji, please continue.
The point I was trying to make was that the tenure of majority judgments was not secured.
Who are they? Can you name them now?
Mr. Justice Karamilahi Chauhan, he was acting judge between 27th April 1978 till
ये
30th.
कहाँ से आप ले रहे हैं? कहीं लिखा
See,
आपने?
मैं सुप्रीम कोर्ट की वेबसाइट से ही
No, have you written it in your booklet?
D clause E में लिखा है सर.
E में.
E में.
Okay, fine, then you don't have to. Fine, we can read it from there. ठीक है, got this point. Next point.
Sir, the next point is about the element of bias.
Ji.
Now, if I may just refer to the paragraphs in which the issue of bias was addressed in the Supreme Court's judgment.
Ji.
It is in paragraphs 841 to 915. And that even included the conduct of setting up a cage in court in which Mr. Zulfikar Ali Bhutto was made to sit in a cage. And Supreme Court found nothing wrong with it.
ये कहाँ है?
So ये judgment के अंदर ही इन्हीं paragraphs में ये सारा
Lahore High Court.
Lahore High Court, which is.
Was that factually so?
It was factually so. It was taken as a ground in a,
No. Did he sit in? Was
he was made to sit. और justify ये किया गया कि so that
it happened, or just we are talking language here?
no, they set up, they brought in a cage-like box in which he was made to sit, and and justification was given that he is to be protected.
By
Protected
whom?
from and by whom? And then they said because this was the first time a trial was conducted by High Court and there was no dock, so that's why we have set up this cage.
किधर है जिक्र?
तो ये
जजमेंट
जजमेंट में सुप्रीम
में
कोर्ट
दिखाएंगे आप हमें जजमेंट में ये केज का जिक्र कहाँ
तो
पे?
ये इनफैक्ट मैंने ये जो मार्क किए हैं पैराग्राफ्स 841 ऑनवर्ड्स, ईच पैरा इज
नहीं हमें हाई कोर्ट का पहले दिखाएं। कहीं लिखा है हाई कोर्ट के जजमेंट में केस का जिक्र?
सुप्रीम कोर्ट ने इंडेक्स बनाया उसमें ये लिखा है।
चलें बताएं।
ये सर पेज 53 से शुरू होता है जजमेंट।
ये केज वाली बात जरा बताएं।
जी सर उसमें सीएमए में थी।
ये नया फलसफा के प्रोटेक्शन के लिए केज की जरूरत होती है।
ह्यूमिलिएट करना, वी ऑल नो व्हाट वाज।
नहीं जरा वो देखें तो पहले, बिकॉज इट्स सच अ लॉन्ग जजमेंट इट्स।
तो ये इनकी इंडेक्स इन्होंने सुप्रीम कोर्ट ने शुरू की थी पेज 54 से और
उसमें तो नहीं बताएंगे ना आप बस बता दें हमें किस जगह हम पढ़ेंगे।
आई एम जस्ट ट्राइंग टू आइडेंटिफाई क्योंकि ईच ग्राउंड वाज सो यूनिक।
I incidentally, Iran, I saw the case. It was iron bar.
किस तरफ था? जैसे ये कोर्ट रूम है किधर रखा हुआ था? ऐसे साइड
जैसे विटनेस बॉक्स का साइज होता है उस टाइप की।
अच्छा ओके ठीक, ऊंचा कर दिया ठीक।
But the other leading up to that are like prisons, which I've seen also many times. Prison bars, but they were like prison bars.
जी
I'll point it out.
इन्हें आगे बता दें, you can always tell us later.
874. Thank you. Paragraph 874. 874. 874 at page 370.
कौन सा पेज बताया खाली साहब?
370
370 page, paragraph 874.
जी पढ़ दें।
In the courtroom, in the High Court, in which this trial was held, there was no dock, and it was therefore installed before the commencement of the trial. According to the appellant, this dock was specially devised to cage, humiliate, and devalue him in public eye. This may be an unfortunate impression formed by him in the circumstances, but otherwise the necessity for segregating the accused was genuine and apparent from the fact that very great interest had been shown by the public in this case. It is therefore difficult to doubt the bona fides of the court in installing the dock in question. Similarly, there appears to be some room for misunderstanding concerning the remarks about the benches against which the appellant was aggrieved. The allegation that as a result of the seating arrangement in the dock, the appellant and his learned counsel were handicapped in communicating with each other in the court for the purpose of this case is not borne on from the record. It does not appear that any complaint to that effect was at any time brought to the notice of the court, or any application was at all moved in court to draw its attention towards any such difficulty experienced by the appellant in the course of the trial. Before us, neither the other accused nor any of their learned counsel supported the appellant in this complaint, nor did they ever make any such grievance in the court. In the course of the trial on 1/1/77, this is a different ground that the Lahore High Court Chief Justice had become the election commissioner, and he had made personal remarks about the misconduct of the accused in elections.
All accused were sitting in one cage, or only Mr. Bhutto?
Perhaps Only Mr. Zulfikar Ali Bhutto.
What about the other accused persons? They were sitting where?
It doesn't. They didn't, they didn't require security, maybe.
Because ordinarily the High Court does not conduct trials. Now, one thing which I wanted to know, how many trials has the High Court conducted in Pakistan's history? Trials. So this was a trial conducted by the High Court. एक तो ये एस्पेक्ट था, मे बी हमें वो क्रिमिनल लॉ एक्सपर्ट्स हमें ये बताएंगे. So that may be a reason, because ordinarily in a trial court the accused sits somewhat separately. So I don't know. That could be the reason.
My Lord, but this, along with the manner in which the appellant, in that case, Mr. Zulfikar Ali Bhutto, was treated, there is an exchange between the then Chief Justice of Lahore High Court and Mr. Zulfikar Ali Bhutto. It's all again narrated in these paragraphs. There was so much vitriol, there was so much heated exchange between them personally, and the reason, rightly or wrongly, was that perhaps the Chief Justice of Lahore High Court was bypassed.
हमारे लिए एक मुश्किल हो गई, which could have been easier way to solve it. There was apparent bias in the Lahore High Court, but all those grounds of apparent bias were addressed by the Supreme Court. Correctly or wrongly, we won't go into that. So to that extent, if we substitute a finding, would be we want to stay clear of the review jurisdiction aspect of it. So ये भी अगर एक चीज miss कर दें Supreme Court, that this point was not considered, would be slightly different from a point considered and repelled.
Well, your Lordship will have to look back at the context. Ordinarily,
वो एक अलग बात है.
so without that, the case would not be could not be appreciated. Now, today we live in a very different society. At that time, thousands of political prisoners were in prisons. People were lashed, people were hanged, and there was absolute ruthless martial law in the country. Now, if the Olympian detachment of today's society, unless we transpose ourselves, some of us who were around at that time, we have witnessed it. Many of the people of younger age, they cannot envisage. Journalists were lashed, and people were imprisoned for years and years for raising a slogan through military court trials. My parents were convicted. The then Lieutenant Commander was a gentleman. He told my father that I've been directed to sentence you for 1 year and your wife for 2 years because she is more abusive of General Ziaul Haq. And this was the trial. So I am a first-hand witness also. But again, I want to stay out of that. I am an amicus. But unless we actually envisage what sort of society we were living in, there was not only bias in the High Court, there was also bias in the Supreme Court. The tenure of the Chief Justice was curtailed. Your Lordships have framed a particular question about that. I'm sure the Learned Attorney General plays the record, but there was manipulation.
What about tenure? You're saying Chief Justice tenure was curtailed?
So, Justice Anwarul Haq had become Chief Justice because of the manipulation. And this was specifically the order passed by this court. Honorable Mr. Justice Iftikhar Muhammad Chaudhary, as the Lordship then was, he passed the order that AG will place the record of the appointment of Justice Yaqub Ali and his removal. So this is the context which needs to be...
Do you know anything about it? Please tell us, we'll make a note of it.
So, in the context of first, when the martial law was challenged...
Justice Yaqub, you said his tenure was curtailed.
Ji, sir. I'll place exact details, but there is a direction to the...
No, we'll ask him, but if you know something, please tell us, or we move ahead.
So when he was not agreeing...
if you have any facts...
So, I have not.
ठीक है, आगे फिर बढ़ते हैं. Let's proceed.
My request would be that perhaps we need to envisage the context, otherwise this case would not make sense. And ordinarily, your Lordship's concern is very valid that we don't want floodgates, that everybody who faced a trial during a particular period comes back. But here is the case where there is a targeted person.
This is a unique case.
Indeed, my
and
Lord.
there's no other case
There
which
is no other case
can be compared with
parallel
it.
yet.
Anything further?
Then, my lords, I have taken some... I have referred to certain judgments of Pakistan Supreme Court and from England and other jurisdictions where particularly there is one case where the judge had intervened too much and then the entire trial was found to be unsafe by the United Kingdom Supreme Court.
But that must be in the judicial hierarchy, right? We're talking about a totally different jurisdiction.
जी बिल्कुल ऐसा ही है.
वो इसलिए उस कॉन्टेक्स्ट में देखना जरूरी है. आप हमें वो ग्राउंड्स तो बता दें ना, मटेरियल तो बता दें जिस मटेरियल से आप ये सारा शो कर रहे हैं. That's important for us to understand. It's a totally different jurisdiction.
So, grounds and material was, first of all, what is recorded in the judgment of Supreme Court itself. That perhaps is more than sufficient to demonstrate that this was a unique case where there was an individual who was targeted through the executive pressure on the judges.
And high now material. Pressure wala.
So there is contemporary material available. There is no first-hand evidence.
जो भी आपके पास है material बताएं. Judge under pressure.
So there was a book published. The author was Victoria Schofield.
बुक्स की बात नहीं है. देखिए एक जजमेंट ये वेल लेबल्ड जजमेंट है, बड़ी लेबल करके लिखी गई है. अब उसमें 22 के पॉइंट को भी उन्होंने देख लिया अच्छे तरीके से. अब विदाउट सेटिंग साइड द सेट जजमेंट हम कैसे दोबारा 22 को ले सकते हैं? पहली बात आपने कहा जी मिसकैरेज ऑफ जस्टिस को हम देख सकते हैं और ये कर सकते हैं. उसके लिए हमें लाजम होगा कि उस जजमेंट को हम सेटिस्फाइड करें. वो हम कर नहीं सकते क्योंकि रिव्यू भी आपने एग्जॉस्ट कर लिया है. अगर वो सेटिस्फाइड कर दें तो फिर उसके बाद जो हाई कोर्ट की जजमेंट है वो इनफील्ड रहेगी. तो आपका मतलब ये है कि आप ये कहना चाहते हैं कि हम इस रेफरेंस में बैठ के 3 जजमेंट्स रिव्यू, अपील और ट्रायल कोर्ट की जजमेंट को पहले सेटिस्फाइड करें और उसके बाद आए. ये कैसे हो सकता है? जबकि 22 को सुप्रीम कोर्ट ने, आप खुद बता रहे हैं, पता नहीं कितने पैरे लिख दिए, उसको डील कर लिए. और देखिए आप जजमेंट को जब देखते हैं तो उन्होंने ईच एंड एवरी पॉइंट को उन्होंने इसको मीट किया है विद द प्रीवियस रेफरेंसेस. वेल लेबर्ड जजमेंट है ये. इसको ये नहीं कहा जा सकते और क्या कर सकते हैं. इसका जवाब दीजिए.
मेरी सबमिशन ये नहीं है that the court should set aside the judgment. That is not possible because that requires statutory provision. What this court can do is to look at the judgment, read the judgment of the Supreme Court, and if your lordships are convinced that the reasons given not on the merits of the case.
इसमें बात तो फिर वही आ गई ना कि we can only render the opinion. We cannot wipe out 3 judgments, Lahore High Court, Supreme Court and the review jurisdiction. So what is the effect of our opinion? What we will hold?
The effect of opinion would be the conclusion that the trial was unsafe. There was miscarriage of justice in that case. And that is where it stops.
And judgment will remain intact.
If they want to undermine the basis of judgment, many other countries, including United Kingdom, have given all
that statutory legislation. Undoubtedly, I mean, strong word, but the judgment is belabored. As we note it, I mean, it's such a criminal case, and I mean, you know, I don't know why we went into such great fine details of it. So, just the fact that an opinion is rendered, naturally you can't undo the judgment, but an opinion in itself may be vindication enough. I don't know.
Perhaps that's what is sought through
No, but
this
that
revelation.
We can start with it. I mean, that's why I keep going earlier in time. Nobody wants to go there. लेकिन यही बात हमारे माशरे में अजीब सी है. जब हम इस्लाम की बात करते हैं तो कोई करना ही नहीं चाहता. हम कह रहे हैं इस्लाम जूरिस्प्रूडेंस में कुछ बताएं तो आप चले जाते हैं अमेरिका और विलायत वगैरह. भाई हमारे आइन में कहीं नहीं लिखा है कि अमेरिका के कानून को फॉलो करेंगे, विलायत के प्रेसिडेंट को फॉलो करेंगे या इंडिया के प्रेसिडेंट्स को फॉलो करेंगे. मगर जहाँ तक हम बात करते हैं कुरान शरीफ की, या आप कोई भी नहीं आता है हमारी ताउन मदद करने के लिए. भाई अगर एक अदालत ने गलती की है, इस्लाम क्या फरमाता है इसके मुतालिक? कुछ कहता है या खामोश? मुझे नहीं पता. मगर मुआवनत तो मैं समझ रहा था कि मिलेगी, मगर मुआवनत नहीं मिलती है. अब यही देखिए ना, हम जब बार बार ये सवाल आपसे उठा रहे हैं. अब फिर अगर आपको ट्रायल्स देखना है, हिस्टोरिकली ट्रायल्स, हजरत ईसा अलैहिस्सलाम की जो ट्रायल हुई थी, सैनहीड्रिन ने जो की थी, तो फिर आप वहां भी जा सकते हैं उस पर एक वक्त में, फिर आप सोक्रेटिस की ट्रायल भी बात कर सकते हैं। तो वो एक जजमेंट ऑफ हिस्ट्री या ओपिनियन भी एक चीज हो सकती है। ऑफ कोर्स उनको खत्म तो नहीं किया जा सकता है कि सोक्रेटिस के साथ क्या हुआ, मगर अगर वो कोर्ट्स अब रही नहीं, मगर जो कोर्ट रही है अगर कुछ दुरुस्तगी की तरफ जाना चाहती है तो तरीक़ेकार क्या होगा, ये बात है। अब
सबसे जो
उसका नतीजा तो नहीं चेंज कर सकते हैं। अब हमने जैसे कि पहले मार्शल लॉ पे बात हुई, फिर जजमेंट आ गया कि गलत है, वो भी तो जजमेंट ही थे ना सुप्रीम कोर्ट के। तो एक तरह से जो भी आप कहें उसको रिव्यू किया या क्या किया, प्रेसिडेंशियल रेफरेंस आया या नहीं आया, मगर एक और जजमेंट में उन्होंने एक और राय ले ली। तो अब हमें सिम्त तो ठीक कर लेना।
आप प्रोस्पेक्टिवली हमेशा डेविएट
कैसे करेंगे ये बता।
आप वो तो कोर्ट की इनहेरेंट जुरिस्डिक्शन है। इफ यू लॉर्डशिप वुड रिकॉल लिवरसिज वर्सेस एंडरसन, a very infamous judgment of Britain. Subsequently, the House of Lords observed that their lordships were excusably wrong in Liversidge versus Anderson. So prospectively,
उनका मसला और हमारा मसला बहुत फर्क है। उनका तो एक तो आईन लिखा हुआ नहीं है, ठीक है, वो उन्होंने कर दिया, कैसे किया मुझे नहीं पता कैसे किया, ठीक है। उन्होंने कहा जी हम हर कुछ कर सकते हैं। अगर आप हमें इतने ज्यादा इख्तियार दे दें, कल आप ही हमारे सामने खड़े होंगे और कहेंगे कि नहीं जी आप पाबंद हैं आईन पे और आप हर कुछ नहीं कर सकते हैं, और मेरे ख्याल में सही कहेंगे। तो वो एग्जाम्पल्स मुझे कुछ समझ नहीं आ रहा है, मैं उनको क्यों फॉलो करूं उन एग्जाम्पल्स को, मगर हमें इस्लामी तारीख से कुछ बताया नहीं जा रहा है।
तो एक सेकंड, एक चीज स्पीकिंग फॉर माई सेल्फ, बड़ा आसान मैं आपके लिए करता हूँ। How I see it, हम 186 में जब किसी चीज को जजमेंट को देखेंगे तो हम कहेंगे उस जजमेंट पास होने के बाद हमारे पास कोई मटेरियल ऐसा आ गया है जिससे सिर्फ ये जाहिर होता है कि उस वक्त जजेस इंडिपेंडेंटली फैसला नहीं कर सकते, कोई मेरिट्स में नहीं जा सकते। आप सिर्फ ये कहेंगे कि जजेस वर नॉट ऑपरेटिंग एज जजेस बिकॉज दे वर आइदर बीइंग डिक्टेटेड और समथिंग। उसका मटेरियल दिखा दें, इतना सा केस है सारा।
सर पैराग्राफ 841
नहीं आते बस सारी बातें गोल।
मगर आप माय लॉर्ड ने जैसे ऑब्जर्व किया सरदार साहब ने कि अगर आप पैराग्राफ पे रेफर करें कि इसका मतलब है फिर हम रिव्यू में बैठ गए,
उसमें तो
ये देखिए
रीजनिंग आप देखेंगे,
गलत किया सही किया कर दिया।
सर वो रीजनिंग आप देखेंगे, एक रीजनिंग ये भी थी दैट फोर्स
मैं आपसे एग्री करूं तो फिर मैं कौन सा जुरिसडिक्शन हूं।
वो रीजनिंग को छोड़ दें, अब आपसे पूछ रहे हैं कि एक हमें पता चला ये केस डिसाइड हो गया, बाद में मटेरियल ऐसे हुए, लोग बोले, कोई मटेरियल आया कि हम इंडिपेंडेंट नहीं थे। आई एम ऑल विद यू, आई जस्ट वांट टू लुक एट दैट मटेरियल व्हिच शोज द जजेस वर नॉट इंडिपेंडेंटली डिसाइडिंग द मैटर, देन मिसकैरेज हो गया। वो दिखाइए ना मटेरियल, और तो कोई एंट्री का पॉइंट ही कोई नहीं है इस केस में। उसने
मैं एक आपको जजमेंट अभी रिसेंटली ऑफ द सुप्रीम कोर्ट इटसेल्फ,
नहीं आप मटीरियल एक्चुअल मटीरियल बताइए ना। ये कहना कि मार्शल लॉ था वो काफी नहीं है ना।
सर मेरी रिक्वेस्ट ये है कि व्हेन अनलेस वी लुक एट पैरा 841 में हाउ बायस वाज जस्टिफाइड, वी वुड नॉट बी एबल टू कम
हम आपकी बात समझ
टू सी द रीजनिंग,
अग्री भी करते हैं, मगर जरा आप हमारी दुश्वारी भी जरा समझे ना। हम ये तो नहीं कह रहे हैं कि हम आपसे अग्री नहीं करते हैं, हम कुछ और बात कर रहे हैं आपसे। जरा उसका तरीके का मतलब अमेरिकस हैं, सॉरी आप पे इतना पैसे डालना नहीं चाह रहे, मगर जरा दूसरी नजर से देखिए।
या तो ये भी हो सकता है, देखें इस तरह हो सकता है कि आप कहें कि जैसे एक जजमेंट है, ये जजमेंट पब्लिक प्रॉपर्टी बन चुकी है, प्रेसिडेंट से हमसे पूछ रहे हैं कि आप बताएं जजमेंट के बारे में आपकी क्या राय है। हम कह सकते हैं कि जजमेंट सही है या गलत है, लेकिन इसको हम चेंज नहीं कर सकते।
एग्जैक्टली यही प्रेसिडेंट ने आपसे पूछा है। प्रेसिडेंट हैज नॉट सेड दैट प्लीज चेंज द आउटकम ऑफ द केस। व्हाट द प्रेसिडेंट हैज आस्क्ड दिस कोर्ट इज वेदर देयर वाज एनी मिसकैरेज ऑफ जस्टिस, टेकिंग द फैक्ट्स एज इट इज।
तो वो कैसे होल्ड करेंगे? हाउ वी कैन रिपोर्ट आवर ओपिनियन अनलेस वी गो थ्रू द एंटायर एविडेंस?
सर आप जजमेंट
वी सी वेदर देयर वाज एनी miscarriage of justice or not, and there was any bias,
और ये अपील की ग्राउंड होती है।
go through the entire judgment
सर आप प्रोस्पेक्टिव ओवररूलिंग करते हैं तो वो अपील तो नहीं होती।
नहीं तो कल को फिर जितनी जजमेंट्स भी हमने दी हैं, कोई हर दफा प्रेसिडेंट ने कह दे इस केस को भी देख लें, फिर हम सारा केस सुने
तो
दोबारा।
हर केस में आप रिजेक्ट भी करेंगे अगर ऐसा होगा?
नहीं ये तो ये जुरिस्डिक्शन का स्कोप नहीं है ना।
देखिए हमें एकदम से सवाल आप पे आ गया है, आप बेशक सोच लीजिए, हम आगे बढ़ सकते हैं। अगर आप मजीद कोई बात कहना चाहेंगे बाद में भी आपको सुन सकते हैं, अगर आप कुछ फाइल करना चाहें। इस पॉइंट पे जरा ज्यादा फोकस आ जाए तो आप आगे बढ़ें।
मैं जी एक आगे पॉइंट कर दूं। एक recent judgment I have referred to curative review. Now in Pakistan it had an odious background, but as a matter of jurisprudence it's a very sound principle. Usme I take the view that it's not available to state or authorities. It is only available to the aggrieved individuals or parties. Recent judgment in Supreme Court in Islamabad High Court case, it has been rejected, but perhaps the underlying reasons may provide some guidance.
नहीं मतलब देखिए ना अब बिल्कुल आपने बुनियादी खराब कर दिया केस का। केस की बुनियाद रखी गई है प्रेसिडेंशियल रेफरेंस पे। इन्होंने फाइल ही नहीं की क्यूरेटिव, हम उसको बैठ के तबसरा करने लगे तो उसी बुनियाद पे रहते हैं, उसी से चले ना। ये नए पॉइंट आप खड़े हो गए।
ठीक है, we leave it for
and all convert the reference into curative writ.
वो अगर
not our right
I appreciate
constitution.
इसी पे रहें
because it's 186 we restrict ourselves to Article 186. So there is a recent judgment of this court and if I may point out, a ground, Supreme Court has now taken this ground that trial should be open or proceedings should be open and transparent. Now, as I pointed out, there was part in camera trial.
कोर्ट में ओपन नहीं थी
सर, एक स्टेज पे फॉर प्रोलॉन्ग ड्यूरेशन द ट्रायल वाज इन कैमरा।
ये फैक्ट प्रूफ दिखाइए इस बात का।
सर इसका ये पेज 171 है सुप्रीम कोर्ट की जजमेंट में, पैराग्राफ 340 ऑनवर्ड्स।
171
para 340 and if I may refer to para 345 sir.
जी 171 लास्ट पैराग्राफ। जी सर।
खालिद साहब इसमें एक और सवाल का जवाब दे दीजिएगा कि जो बात हो रही है, the other brothers have also asked this question, how this case was directly tried by the High Court. Under section 265B CRPC there is a provision that the High Court can also try the cases like session court, but how it was transferred, whether there was any judicial order, there was any notification of government that this should be tried by the High Court and not by the session court.
An application was filed, perhaps by Mr. Kusuri, I may be corrected, and without notice to the accused, the case was transferred.
I think one of the amicus would attending to criminal trial will be attending to this point.
But for direct transfer ho gaya tha without notice to the accused.
Okay.
So para 341, 340, 45 agar hum pad lete hain sir. In the detailed order dated 9/178 passed on the transfer application, it is mentioned that it was decided to be taken up in chambers, and since not only it is the usual practice of the court to hear motion cases in chamber, but also the intention of the accused in repeating previous petitions based on allegations of bias appeared only to give publicity to the baseless allegations of a scandalous character and thus undermine the confidence of the public in the courts of the country. On appearing before the bench, the appellant expressed his surprise and made a request for the petition to be heard in open court. This request, according to the learned trial bench, confirmed their views that the object of the accused petitioner was clearly to give publicity to the highly scandalous, scurrilous and baseless allegations in the petition and the arguments that might be addressed in that connection. Therefore, the bench did not agree to the request of the appellant. In these circumstances, the learned trial bench heard the arguments in chambers on the transfer application in the presence of the appellant and of his two learned counsel. It appears that in the course of arguments by Mr. Dos Mohammad Awan, his learned senior counsel, the appellant intervened to make certain submissions of his own despite the fact that it was brought to his notice that he was interfering with the proceedings. After the conclusion of the arguments by his learned counsel, the petitioner was also allowed an opportunity to supplement the arguments on facts as a special case. However, according to the impugned order, the appellant started a political speech in the court. He was asked several times to confine himself to the petition and refrain from making a political speech. Ultimately, he took his seat, saying that if he was not allowed to say what he liked to say, he would not make his submissions. I shall separately deal with the merits of the allegation contained in the transfer application and the order passed thereon at the suitable place in his judgment, but for the present, suffice it to mention here that the appellant had taken exception against the hearing of his application in chambers on wholly untenable grounds and had therefore on the same day voluntarily chosen to dissociate himself from the proceedings at his trial in open. Then there is discussion of what is open trial mean, what open trial means. The Chamber's dictionary is relied upon, and then the application was dismissed. And on the sole ground that he may make scurrilous or scandalous attacks on the court. This again vitiates the proceedings, and it is completely incompatible with the jurisprudence of this honorable court, particularly in recent years, that open and...
Any other point?
So finally, I have enumerated the statutory provisions in different countries.
वो तो ठीक है, हमारे यहाँ है नहीं तो क्या करें?
जी सर,
वो आपकी बात दुरुस्त है, पार्लियामेंट कल बनाना चाहे कानून बनाए, हम पार्लियामेंट को कोई हुक्म, मैं तो नहीं देता हूँ हुक्म,
वो तो recommendation because president is part of parliament.
जो मर्जी करे.
And then I have enumerated the cases which deal with bias, and in each one of those cases, it was sufficient that even if one member, particularly...
बात कह दी.
जी सर.
ठीक, एनीथिंग एल्स?
I'm
अगर
grateful,
मजीद
sir.
आपको कोई कहना हो या कुछ फाइल करना आप कर दीजिएगा.
सिर्फ
हम
मैं
जरा आपको इसलिए जरा जल्दी कर रहे हैं क्योंकि और भी काफी लोग.
जी जी, I understand. I'm very grateful, sir.
No disrespect intended.
No, sir, I'm very grateful. सिर्फ एक recently, अगर if I may read one paragraph from the recent judgment passed by this honorable court, if I may lay my hands to that. One of the learned sitting members of the Supreme Court has passed an order and made observation about the trial in Zulfikar Ali Bhutto case itself. So it's in the...
Why are you referring to that?
So the present honorable judge of the Supreme Court observed that the conviction in that case was unsafe.
What?
It's one of the rarest of cases.
ठीक है, उसको छोड़ें. No, नहीं, वो तो एक जज, let's leave that.
But I just wanted to
Reported
indicate...
judgment हम पढ़ लेंगे.
Is that by a bench or what?
Reported judgment है.
It's a reported judgment.
Just give us a citation.
जी sir. It's authored by Mr. Justice Athar Minallah, and it's Islamabad High Court Bar Association case. I'll give the exact citation, my lord. I've somewhere taken it out.
Yeah, reported है.
जी sir.
PLD 2023 Supreme Court 720. I think this is the one you're referring to.
Yes, my lord.
Islamabad High Court versus Election Commission.
G selection, exactly.
We'll go through it.
Mr. Justice Athar Minallah had made.
So then you've got a declaration.
So,
What do you want more?
your lordships are invited to join the declaration.
नहीं वैसे कह रहे हैं कि सुप्रीम कोर्ट ने कह दिया.
तो उतना ही शायद president is expecting that your lordships would share that opinion. I'm very grateful, sir.
Thank you, Mr. Khalid Javed Khan. Who's coming next? Is Mr. Salahuddin Ahmed coming next?
23.
Salahuddin साहब आप आ रहे हैं पहले? Next. जी. Have you also filed something?
Yes, sir. I filed a note, and then there are two books of the materials.
हाँ? तो बड़ी मेहनत की आपने.
कोशिश की है थोड़ी.
ये वो repetition तो नहीं है जो मखदूम साहब ने फाइल किया?
I haven't had the opportunity of looking at Makhdoom Saab's. There are two booklets. One is on advisory jurisdiction and the other is on bias and miscarriage.
Bias and miscarriage. अच्छा जी, ठीक है. And you filed CMA number?
Sir, this filed today. It's
13, आप note कर लें, 1359.
1359.
2024.
हमें भी दे दीजिए अगर है.
1359 2024. Do you want us to open the CMA or you want
The CMA, sir.
जी.
नहीं, दोनों मेरे पास दो हैं. 1359.
Sir, in essence, what this reference asks, if all those 5 questions are distilled, is whether the conviction and execution of Zulfikar Ali Bhutto amounted to miscarriage of justice. But can this court answer this question under 186? If so, to what extent? And are there any other avenues available to address miscarriage of justice? And even if this court reaches the opinion that it was a miscarriage of justice, what is the legal effect and consequence of that opinion? Now, first of all, sir, there are a couple of principles relating to advisory jurisdiction, which I may briefly advert to. Number one is that only questions of law can be gone into. India or Canada may, or England may be. I've given the relevant statutes and the constitutional provisions in the note. There you can go into questions of fact and law. But in Pakistan, obviously, we're confined to questions of law. The impact of that is, sir, that as far as some of the factual issues are concerned, whether a judge was biased in fact, factual bias agar tha ya nahi tha, whether due to pressure from martial law authorities or due to personal animosity being superseded, etc., those questions perhaps cannot be gone into because they are factual questions. Number two, that the president is the sole judge of the public importance of the question and the desirability of referring it to the Supreme Court. Number three, that because of the mandatory language in 186, the court cannot refuse to consider the reference. It has to consider it. It may nonetheless report its opinion that one or the other question is not capable of answer because it's not a question of law, it is a question of politics, or it is too vague or general, or it has already been addressed in earlier decisions. Even that is a ground on which not to give an answer. The fourth is, sir, that this court under 186 does not have suo motu powers, and it does not have the plenary power to do justice as in Article 187. It is only confined to answering the President's questions, albeit with the caveat that if the President's questions are vague or imprecise, this court has the power to narrow down and refine those questions and isolate the precise legal issue that requires answering. That power is available. But
which has been exercised
already. Your lordships are doing it as we speak.
No, before us, the bench had reformulated the questions also.
Now, finally, sir, these are the 2 points which I think are very important for this case. The fifth is that this court cannot set aside earlier decisions made in adjudicatory jurisdiction, whether in point of fact or in point of law. At least as far as the decision inter partes is concerned, that cannot be touched. It is res judicata. Uspe, sir, there are a number of judgments which I'll just come to, but the sixth point is one in which there is a divergence in the case law. Even if the judgment itself is res judicata inter partes. Obviously, as your lordships often do in subsequent cases, your lordships modify a principle of law laid down in an earlier judgment, the concept of stare decisis as opposed to res judicata. Your lordships frequently amend, modify, correct principles of law that have been laid down in earlier judgments. The question is whether your lordships can do so under Article 186. Now in India, there were two views taken. The Indian Supreme Court in the reference relating to Qazi, there the Supreme Court said that because we are in the advisory jurisdiction, we can neither set aside an earlier judgment, we cannot affect its finality inter partes, nor can we deviate from the principles that have already been laid down in the adjudicatory jurisdiction.
Which judgment was this?
Sir, this was the judgment of Qazi 2 reference. It is reported at AIR 19.
Which is it here?
Ji sir, tab number 6.
Of volume 1?
Ji sir.
What is the citation, AIR?
AIR 1992, Supreme Court 522. और उसमें सर relevant para जो है, I'll just take that.
Qazi. Can you repeat the citation?
AIR 1992, Supreme Court 522. And this is tab number 6 in the first booklet. और इसका सर जो relevant para है वो 21 to 23 है.
जी.
I'm sorry, I just.
जी.
I'm sorry, sir. I'm just trying to isolate the part. जी सर, ये पेज 254 पे होगा सर.
It starts at 522, you said.
नहीं ये इनका हाथ में लिखा है.
अगर बुकलेट में सर पेज 254 देखेंगे. ठीक.
जी.
And इसमें सर this court by its decision this court by its decision of April 26, 1991 has held as pointed about above that the central government had made a reference to the tribunal for consideration of claim of interim relief paid by state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request. Being a part of the reference, implicit in the said decision is the finding that subject of interim relief is a matter connected with or relevant to the water dispute within the meaning of section 5(1) of the Act. Hence, the central government could refer the matter of granting interim relief to the tribunal for adjudication.
Which page are you?
Sir, this is at 254 of the
Handwritten.
booklet.
Fine. Please carry on. Please.
Yes, sir. Although this court by the said decision has kept open the question with whether the tribunal has incidental, ancillary, inherent or implied power to grant the interim relief when no reference for grant of such relief is made to it, it has in terms concluded the second part of the question. We cannot therefore countenance a situation whereby question 3 or for that matter question 1 and 2 may be so construed as to invite our opinion on the said decision of this court.
Basically, they said you can't do it.
You can't do it.
Yes, but then they changed their own view.
Yes, sir. They changed their view in the subsequent judgment which was referred to by Mr. Makhdoom Ali Khan. That was the 2G reference case.
2012.
जी सर. वहाँ उन्होंने ये कहा
ये भी 5 मेंबर हैं, वो भी 5 मेंबर हैं.
जी सर.
तो I'm not very clear.
Yes, sir. Now, in the 2G reference, they said
why we again placing so much emphasis on these Indian judgments?
Sir, I'll just come back to the Pakistani jurisdiction, but my point is this. In the 2G reference, they said that inter parties we cannot change the decision, but principles of law we can redefine, modify, correct.
Change the ratio of the judge.
Change the ratio. Now, In Pakistan, sir, this has been followed, and I think your lordship was referring to that. That was in PLD 2013 Supreme Court 279. वो जो appointment of judges वाली reference थी, उसमें Qazi 2 was followed.
And just for myself, you see, what according to you is the question of law that you see in this case?
Lord, in this case, the question of law that I feel that has not been answered before is the question of bias that arose on account of the interview and the book of Justice Naseem Hassan Shah. That was a question that was never previously dealt with by the court.
So how do you frame the question of law?
My lord, the question is whether the judgment was vitiated by bias on account of the revelations made by
a judge later on.
Yes.
Fair enough.
If he gives this opinion, what will be the impact of that judgment?
My lord, the effect of that judgment, if your lordship, there are two separate strands here, sir. If your lordship takes the view that was taken in Qazi 2 and in appointment of judges case by this court, that even principles of law cannot be changed, even then your lordships can give an opinion that there was subsequent bias that wasn't ever considered by the court, and we can give our opinion on that. What that opinion will do is it will not change the principles of law in Zulfikar Ali Bhutto, but it will nonetheless give some vindication.
We will ask the judges to be careful in future.
My lord, and this is why I said that the desirability of the reference, that is a question for the president.
Is this the only bias you are claiming?
My lord, all the other instances of bias, and I think there are numerous, which Khalid Javed Khan Sahab bhi jinka tazkara kar rahe the, but the problem is that in one way or the other, even the bias of Justice Anwarul Haq, there was a specific application moved to the Supreme Court which was rejected by the Supreme Court. That was also reported. So all those aspects of bias were covered. Some of the aspects of bias...
But you are forgetting another overall bias. Why not the manner you are attacking now, the bias in the system in its entirety, which the Supreme Court had not considered itself in that case. The fact that if we do not convict, the persecuted may become the prosecutor tomorrow, that the Supreme Court judgment doesn't say, and invoke Article 6, that we may lose our job. I mean, so what about those things which are part of history but not articulated in the Supreme Court judgment at all, and not which may have been alluded to? I mean, whether Justice Naseem Hassan Shah says it or not, these are facts of history. So what about that? Can that be not considered as a bias which the court did not consider, and it would not have considered it?
My lord, the difficulty that I have with that, and there are of course things which are historical fact, but the difficulty I have with that broad proposition is that it is difficult to decide then where to stop it. Which of the judgments that were rendered during that period should be retained? Which of those judgments should be assailed? Because although
May I solve your difficulty? There is only one case before us, presidential reference. So why are you worried about whether there'll be another presidential reference? We'll attend to it. Some short answer could be that there's only one case before you.
My lord,
it does open floodgates of future.
That is the concern that I had. That is the concern that I had.
Now, Sahab, आपके paragraph 4 में page 5 पे in your paper book, They have already stated that the question of bias has been decided by the judgments of the court and it has become a res judicata.
Yes.
तो आपके हिसाब से तो आप bias को भी नहीं देख सकते.
नहीं
What is your opinion?
सर, जो बायस उस वक्त तक जुल्फिकार अली भुट्टो साहब के वकला ने जो उनके मालूमात में थी, जो उन्होंने प्लीड की, वो तो तमाम चीज खत्म हो चुकी है. मगर जो चीज बाद में इंकशाफ हुआ, that bias.
आपका फिर क्वेश्चन ऑफ लॉ ये बनता है कि क्वेश्चन ऑफ लॉ ये है कि there was a miscarriage of justice because subsequently we discovered through some material that the judge was not independent at that time. This is the only question.
Yes.
My next question would be कि एक तो उसको देख लेते हैं उस material को. Secondly, you're also saying that in this question of law we cannot inquire into the factual dispute.
Yes.
So this either this material ought to be just undisputed. And then we could rely on it. Because it's a question of law we need to answer. We can't get into inquiry. We cannot probe into matters. We can't look at facts. So, but अब फिर question तो बड़ा simple हो गया. There's miscarriage of justice because of the subsequent material that came to surface, and whether at all that affects the judgment.
Yes.
अब आप जो with the worry that you place about floodgates of litigation, one could also say that when judges retired, people will be running after them to write a particular book saying a particular thing so they can undo a particular judgment. I mean, you mean to say that is more important and we should ignore the other bias which is inherent in the whole system at that time, which is not important, and this particular book or this particular interview becomes more important. I have difficulty with that. I can accept the earlier proposition more than the latter one, and maybe some others have the other view. So I don't know.
Very difficult for a judge to write this eventually, that he was under pressure.
I was trying to think of any other example and I couldn't think of any other example where a judge has
No, but
said
he doesn't even go that far as to say. He says I'm under pressure. I can always say I'm under pressure all the time, you know. That's a general thing. But to say I decided this case wrongly, intentionally, it should have been the other result, is a different thing.
That's right.
I mean, you know, judges, every case, every murder case, every session judge would be under pressure. What should I do? I mean, I don't know.
So if we can get done with this material first, which we say that is the sole document which establishes miscarriage, talks about a generic pressure.
No, sir. There are at least 4 specific places where he talks about
pressure कह रहे हैं ना, मगर वो ये तो नहीं कह रहे कि मैंने हाँ
नहीं सर, मैं उन पे आऊंगा. अगर एक चीज मैं उससे पहले
but proceed in your own way.
जी मैं अभी उस पे आता हूँ. I'll come to bias immediately. ये para 4 से ही. Now, sir, bias, as your lordship had observed on the last date of hearing, bias is sometimes an inappropriate term because bias implies manifest partiality or favoring someone, whereas जो case law में bias use किया गया है, उसमें the concept is any extraneous consideration to judicial adjudication. So that is, sir, I have pointed out a judgment of that is at tab 12 of the UK House of Lords, that's Davidson versus Scottish ministers. I won't read it, सारा मैंने उसमें include किया हुआ है, but any extraneous factor to the adjudication.
But in this particular case, in a reference coming out of 186, that extraneous consideration must be outside the case also.
Yes.
It cannot be something that was discussed,
Yes.
even though extraneous, but discussed in the judgment.
Yes, yes. So it has to be extraneous to
Extraneous
the
in the
earlier
real sense of
judgment and extraneous.
But in time and space, it must be extraneous.
Yes,
Mrs. Lauddin, suppose हम ये मान लेते हैं कि yes, the man has given interview और हम समझ लेते हैं कि वो ठीक कह रहा है. Again, what would be the impact of that interview upon the judgment which has been upheld by the Supreme Court, not only in appeal but in review as well?
सर सदर साहब ने आपसे सिर्फ इतना सवाल पूछा है कि whether according to the law this judgment is to be considered a good judgment or not, or it is to be considered as affected by bias. If your lordships give your opinion that in our view, as per the law, it is affected by bias because of XYZ, That is all he asks. There is no more, even if your lordship sees the reference, reference mein kahin ye nahi likha ki whether the judgment should be set aside or annulled or...
What about Davidson? What did you want, which paragraph you want us to read?
Sir, ye tab 12 hai.
We've got it before us. Which, any particular thing you want us?
Sir, the specific is...
What do you want us to see in here?
My lord, they say...
Acha, page 485, pe, this marked portion.
Ji, sir.
The word bias
Yes, sir.
is a convenient shorthand, but it would be a mistake to approach it in this context as if its only meaning were pejorative. The essence of it is captured in the convention concept of impartiality. Is this a bit?
Yes, sir. This bit, and there's an earlier bit at paragraph 5, I think it is, sir.
हाईलाइट किए हुए आपने
Page 40,
Sir, paragraph 6. Sorry, paragraph 6.
Paragraph 6
Ji.
and paragraph
478 pe.
47.
Ji, sir.
Theek.
Where they say the expression is not a happy one since bias suggests malignity or overt partiality.
Mr. Salahuddin, we would love to read these judgments in the entirety.
I would just...
No. We would love to read these judgments in the entirety, but if you, probably we will not because of so much work. So you'll have to specify this paragraph.
They are written, sir, paragraph 6 and 43.
कहाँ लिखा है आपने चीजें?
Sir, ये मेरे note में,
Okay.
footnote pe I have put the
Okay,
paragraph.
fine, then it's good enough. ठीक.
Sir, bias can be of two kinds, which Mr. Makhdoom Ali Khan had already pointed out, so I'm not going to belabor it, but there is the actual bias, which is sometimes referred to as bias in fact or subjective bias. That involves ascertaining the state of mind of the judge. And that is obviously a very difficult exercise. The more common type of bias is what is referred to as bias in law or objective bias, or sometimes as apparent or perceived bias. Now, in that, a judge may not actually be inclined or predisposed in a particular way, but a fair-minded and reasonable observer would conclude there was a reasonable possibility of the tribunal being biased. That is the latest test. The case law has gone back and forth, etc. But this is the latest test. Ye, sir, maine footnote 22 pe I have put down the. And this is, of course, just another way of saying justice must be seen to be done. Now, in this particular case, sir, the fair-minded observer would have entertained the reasonable possibility that the tribunal is biased on account of at least 4 things that are stated by Justice Naseem Hassan Shah. Isme, sir, if your lordship can first look at the book and then at the...
So objective bias, according to you, would be bias which doesn't require further inquiry, and a reasonable man could suppose that there is bias.
Yes, and that your lordship can conclude as a matter of law, with no factual...
Factual inquiry is required for that.
Exactly, exactly. अब सर पहले किताब पे आ जाते हैं और फिर उसके बाद जो इंटरव्यू है
जी
किताब सर पेज tab 20 hai. It's the second book, sir. Sorry, 21. Isme the relevant chapter I have included. If your lordship will see 666.
Sorry, can you repeat that?
Sir, 666. Tab 21.
Ji.
666.
666. And if your lordship sees the third line, I think part of it has already been read by Mr. Makhdoom Ali Khan, so I won't take up your lordship's time. But in this, he says that Justice Mushtaq Hussain, Chief Justice of the Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, came to see me. Now, sir, The reason why this, and they asked me that I should sit in on the appeal. Now, the reason why this is not an allegation, at least I'm not using it here as an allegation that he made against Mr. Justice Mushtaq Hussain or Mr. Justice Sharifuddin Pirzada, but your lordship will recall that Justice Naseem Hassan Shah was himself hearing, and he was part of the bench that was hearing the bias of the Chief Justice of the Lahore High Court. Now, at the time, if the Chief Justice of the Lahore High Court, after having made a decision, comes to a Supreme Court judge and says that you should sit in on the appeal against my decision, now that is a relevant matter that Justice Naseem Hassan Shah ought to have disclosed at the time when he was hearing the Bhutto appeal. And especially when 90 paragraphs are devoted to the point of bias of the Lahore High Court.
So you're saying that when the meeting took place, Justice Naseem Hassan Shah was already hearing the matter?
No, he heard it subsequently. But he ought to have disclosed it not only to all his fellow...
Oh, this fact.
लाइनों में, however, few days later, the Chief Justice informed me that the full court strength was 9, and he would like to keep this strength. And since I was the 9th judge, I shall have to sit on the bench for this appeal hearing.
बिल्कुल.
ये reason दिया उन्होंने.
जी,
9 जज चाहिए थे, मैं आखिरी था उनका 9 जज का बेंच बना.
Salahuddin, before we come into the latter part of the thing, I mean, I think this is very inappropriate conduct for a Chief Justice to approach a judge of the Supreme Court to say, sit on the appellate bench.
Yes. It shows your personal interest in the outcome of the case.
This fact in itself, that's a lower forum coming to the high Supreme Court with the Attorney General and saying sit on the bench. I mean, I thought this in itself would be this, I think, is more damaging than whether he should have sat as a ad hoc judge or not as an ad hoc judge. I think ad hoc judge's constitution makes it very clear as all the powers of a normal Supreme Court judge. So let's not go there. But why is nobody pointing out this fact that Mr. Justice Mushtaq Hussain, Chief Justice of Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, had come to see me. I went to the guest room to meet them, and after exchange of usual civilities, the point of the visit was explained. The point of the visit was their visit.
Yes.
They wanted me to sit on the appellate bench. So a High Court judge is dictating to the Supreme Court judge. I mean, I find
and he's
this
coming with the Attorney General of the time.
really, I find that amazing. I mean, you know, I don't know if this ever happening.
Well,
And sit on, you please sit on a judgment and uphold it.
had this revelation been made at the time, this would have been a completely independent ground for setting aside the Lahore High Court judgment. And additionally, what I am pointing out is
एक तो ये
that
point
this-
है, what is the additional point? Yes.
additionally what I
ये
am
जो कुछ
pointing out
लिखा हुआ
is
है, ये जो कुछ लिखा हुआ है, इसको क्या कहेंगे? इसको हेयर से एविडेंस नहीं कहेंगे। इसकी क्या वैल्यू क्या है?
मैं-
बंदा रिटायर्ड होने के बाद किसी के बारे में कह दे कि वो मेरे पास आया था, उसने मुझे ये हुक्म फरमाया था।
मैं इसीलिए
ये हेयर से एविडेंस में आएगा जब तक कि उससे कंफर्म नहीं होता कि मुश्ताक से या दूसरे किसी और से।
सर इस पे मेरे दो पॉइंट्स होंगे, and this is the additional point that I was saying. There is one, the weight of what Justice Naseem Hassan Shah has said about the Chief Justice of the Lahore High Court. Then there is the statement as far as he is concerned. Personally, he has made this statement. This is not hearsay.
On a technical point, was when this book was published, was Justice Musaq Hussain alive?
My lord, I do not know. I have not been.
You know the date of publication of this book?
सर जो टाइटल पेज था उस
अगर
पे
कोई ये
date
देख
नहीं
के
थी।
ये भी हमें
ये
पॉइंट
मैं
बता
देख
दे
के-
बाद
ये मैं देख के-
में बता दीजिएगा कि डेट ऑफ पब्लिकेशन एंड डेट
का चांस भी मिला या नहीं मिला?
2002 apparently, sir.
और उनका वो कब तक जिंदा थे?
पहले हुई थी डेथ उनकी।
At least Sharifuddin was present. He was alive.
Mr. Pirzada was alive. He passed away recently. I'm not sure about it.
9-member bench कोई need of the hearing of appeal तो नहीं थी ना सुप्रीम कोर्ट में? 7 भी हो सकता था,
जी
9 नहीं हो सकता।
जी मेरा पॉइंट जहां तक जस्टिस शाह के बारे में था वो ये था कि at least as far as the visit is concerned, whether this was evidence against Justice Maulvi Mushtaq or not, it was, as far as he was concerned, it is admissible. He is saying that someone came to meet me now and asked me to sit on the bench. So this was something, when you were hearing the bias application in the Supreme Court against the very same judge, this was a judicial duty of Justice Shah to mention it to all the other members of the bench and to also inform the defense counsel.
But he didn't, not because of this saying of that he made himself sit on the bench. The Chief Justice of the time decided.
I'm not saying that
But he
he
should
made
have
himself.
disclosed, you see.
He should have, when he was sitting, whether he was rightly, wrongly included on the bench is a different thing. He was on the bench.
Disclosure
He knows that an application of bias against a particular person is being made. A particular incident about that person which reflects the bias is in his knowledge. He was under a duty to disclose it to his brethren as well as to the defense counsel.
So you mean that he was influenced? He was
The fact that he did not do so is a fact that would cause a reasonable observer to conclude, to come to the possibility that the tribunal was biased. If he knew about this bias of the Lahore High Court Chief Justice and he kept it to himself, he rejected the bias application.
When was the bias application filed?
Sir, there are two. One was in an interlocutory stage. Interlocutory stage पे उन्होंने कहा कि नहीं पहले आप ये ground नीचे जाके bias of the Chief Justice of Lahore नीचे जाके.
It will depend when did this particular conversation or meeting take place.
Yes, sir.
Because if we go by what you say, fine, that's बिल्कुल ठीक है, लेकिन वो depend करता है कि वो application कब आई थी, इस meeting से पहले या इस meeting के बाद.
जी सर. Sir, वो जो judgment है, because it was part of the final arguments of Mr. Yahya Bakhtiyar, and the judgment, it is mentioned.
नहीं, आप वहाँ ना आए ना. आपका contention ये है कि जज साहब को उस टाइम पे डिस्क्लोजर करना चाहिए था. ठीक है, वेल एंड गुड, बिल्कुल सही है, करना चाहिए था. अब बात ये है कि ये जो कॉन्वर्सेशन हो रही है, मे बी दिस इज प्रायर टू दैट, मे बी इट्स आफ्टर दैट. सो अगर ये पहले हुआ होता और वो बाद में आए, फिर बात बनती है. तो वो हमें कैसे मालूम होगा?
Sir, I will check exactly the date of the application, but the point I'm making is, at any time before the final judgment, he should and could have disclosed it, because the final judgment has about 50 pages that deal with the bias of the Lahore High Court. So at the time of rendering the final judgment, तब तो ये वाकया हो चुका था, तो तब उसमें तो जिक्र करना चाहिए था और उससे डिस्क्लोजर भी हो जाता।
सलाउद्दीन सर
जी,
ये दो अफराद जो गए, the then Chief Justice of High Court and Mr. Sharifuddin Pirzada, asking Justice Naseem Hassan Shah to sit in that bench, whether that was their own request or they have conveyed the message of someone else.
we do not know. We do not
Because
know
the
from this.
Judge of the High Court going and asking the Chief.
There are other reports about this, but I'm trying to keep it because then factual inquiry की कहानी ना शुरू हो जाए, तो that's why I'm trying to keep it
लेकिन इसको जरा
confined.
आगे पढ़े ना, वो कहते हैं I told them that I was an ad hoc judge. ये पढ़े जरा.
जी sir.
He actually says
He is
this is
giving an
wrong.
explanation.
Yes. इससे पहले भी वो कहते हैं कि normally these kind of cases were
जरा
never
पढ़ ले-
placed
जरा
before
पढ़
ad
ले,
hoc.
so he qualifies it. पढ़े?
जी.
They wanted me to. You underlined it. They wanted me से पढ़ ले.
They wanted me to sit on the appellate bench being constituted to hear Mr. Bhutto's appeal in the Supreme Court. I told them that I was an ad hoc judge and it was therefore not proper for me to sit on the bench. I also felt that it was wrong for my...
So why would a judge of the Supreme Court give an explanation to the Chief Justice of a province? That means that they have conveyed the message of someone else.
Perhaps, yes, that is a reasonable conclusion to draw, yes.
I also felt
that it was wrong for my two guests, being interested parties, to broach this subject with me. They were fully aware of this situation, but still insisted that I must sit on the bench. I was not agreeable. However, after a brief discussion, I made it clear that I shall do as directed by the Chief Justice, knowing that the Chief Justice was a man of judicial integrity and these two worthies, in spite of their personal relationship with the Chief Justice, would not take this matter up with him. However, a few days later, the Chief Justice informed me that full court strength was 9 and he would like to keep me on this keep this strength, and since I was the 9th judge, I shall have to sit on the bench for appeal hearing. Sir, apart from this, there is another aspect.
तो काफी क्लैरिफिकेशन तो दे दिया उन्होंने इसके अंदर, आई थिंक
नहीं, बट ये बात जरा उन्होंने जी
सर मैं ये तो कह नहीं रहा, and it will go slightly into speculative कि वो बेंच में वो हिस्सा नहीं बनने चाहते थे, कैसे इंक्लूड किया गया, क्यों किया गया, चीफ जस्टिस साहब ने क्यों किया, मगर ये वाली बात जो लाहौर हाई कोर्ट के चीफ जस्टिस साहब का जो पर्सनल इंटरेस्ट था केस का, वो और जिस चीज का उन्हें इल्म था, वो चीज नुमाया करना चाह रहा था.
उन्होंने क्या चीफ जस्टिस ऑफ पाकिस्तान को इन्फॉर्म किया कि मीटिंग के लिए आए थे ये दोनों हजरात मेरे पास?
We do not know, sir. It should have been disclosed to all the members of the bench, because your lordship will recall that 3 of the judges had disagreed. So perhaps if this fact had additionally come to the knowledge of all the judges, perhaps it could have been 4 or 5 who said कि नहीं रिमांड करके लाहौर हाई कोर्ट में दोबारा ट्रायल करवा देते हैं नए बेंच के सामने. That could have happened if he had disclosed this fact.
But he actually sets the standard, the bar. He says that the Chief Justice is a man of judicial integrity and they would not have had the dialogue with him. But
nonetheless it happened.
But they could have it with me.
सर एक दूसरा एस्पेक्ट है जो इनके मेमोइर्स से सामने आता है, एंड ये पेज 669 पे है. दिस इज अबाउट द नेगोशिएशंस दैट वर कंडक्टेड बाय हिम to reduce the sentence from death to life. ये सर 669 पे है. And this is relevant to the factor of extraneous considerations. Any consideration, bias can be any extraneous consideration. If your lordship will see 669 pe second para, I can now tell for the first time how the Chief Justice and I made an attempt to save Mr. Bhutto's life. Again, it is the Chief Justice and I. He's personally taking responsibility. With 4 judges hailing from Punjab, apparently in favor of upholding the judgment of the High Court, convicting Mr. Bhutto, and sentencing him to death, while the remaining 3 judges being of different viewpoint, the responsibility and strain on the shoulders of Chief Justice Anwarul Haq was overwhelming. Being a patriot to the core, he was deeply distressed and disturbed by the news reaching him to the effect that in case the court decided to hang Bhutto, a very negative impression would be created in other provinces, especially the province of Sindh. Speculation was that in such an event, the rift between the provinces would become difficult to reconcile and they would not be able to work in harmony in the future. A disastrous scenario was painted for the unity of Pakistan. Such a situation, Anwarul Haq, Chief Justice, considered very serious and was so keen that it should be avoided if humanly possible. After giving deep thought about how to handle this difficult situation, wherein demands of justice should be met, but at the same time the catastrophic effects on unity of federation may be averted, he conceived a device which he considered might salvage the situation, and I was chosen by him to play a role in the implementation of this device. He knew that my relations with Justice Dorab Patel, puisne judge of the court, were very cordial, and throughout the hearing of the case, I had not expressed myself in categoric terms or given any definite view on any aspect of the case. Indeed, journalists reporting the case had repeatedly written that my final views could not be deciphered. Consequently, it was suggested to me that I might have a detailed talk with Justice Dorab Patel regarding the case and the general situation in the country. Being the senior-most judge of the faction favoring the view that Mr. Bhutto was not guilty, he was in an ideal position to handle the situation. The proposal put forward by Anwarul Haq, Chief Justice, was that a unanimous verdict may be handed down by the court so as to obviate all provincial acrimony. According to him, the fairest solution would be if the Punjab judges could be persuaded to agree to award a lesser sentence to Mr. Bhutto, thus saving his life, while the pro-Mr. Bhutto judges might agree to hold him guilty of the death of Nawab Ahmad Khan. Being of the same view and eager to save Mr. Bhutto's life, who had been very kind to me personally, and then he goes on to say, I readily agreed to approach Justice Dorab Patel. This is in fact, the meeting with Justice Dorab Patel is in fact corroborated by Justice Dorab Patel himself in his interview, which Makhtoom Saab had also referred to. But the point is, even the consideration of provincial acrimony in the verdict, that is an extraneous consideration. This is an extraneous consideration that is admitted to by Justice Naseem Hassan Shah when he says that I went to negotiate on this platform.
This shows impression that the judges are deciding cases on the basis of their area, their provinces.
Yes. On basis of political considerations.
Is this not a bias?
Yes, that is the case. That is the case. Now, after this, sir...
Complainant belongs to which province?
Sorry?
Complainant belongs to which province?
Complainant belongs to Punjab as far as I know, sir.
No, ये कहाँ से निकाली आपने?
Now, sir, जहाँ तक interview का सवाल है, there are a couple of things that I would point out.
Is it a confession? Is it an admission? Is it a correcting the historical record? What do you make of this memoir? What do you make of it? Your personal opinion?
These statements are admissions, prior admissions in writing adverse to the interests of the person making them. If it was a court of trial even, these admissions could be admissible under Article 46(1) and 46(3), I think it is, of the Qanun-e-Shahadat. These are admissible statements. But over here, that is not the standard that your lordships are to apply. Your lordships are not sitting as a court of factual inquiry. Over here, the test that your lordships are to apply is, as a matter of law, is that what would a reasonable observer of judicial proceedings, what conclusion would he draw as to the safety of the proceedings after these revelations were made in front of him?
We go back to due process and fair trial.
Yes.
So this paragraph that you've read, 669 onwards, what do you draw from this? I mean, what's the
जी, जो 669 onwards है सर, उसमें ये है कि he admits that he was prepared, he was trying to change the verdict on the basis of considerations of provincial acrimony. That, with respect, is a non-judicial consideration. It is an extraneous consideration, and a judge cannot refer to these things while coming to a judgment and negotiating with a fellow judge.
Well, he was influenced from that the repercussion may be so that it cannot be controlled. Therefore, lesser punishment की तरफ वो जाना चाह रहे थे.
जी सर, बेशक, but it was not permissible.
वो तीन मान नहीं रहे थे और ये तीन बीच का
This is
रास्ता
the
निकालना
dialogue
चाह रहे
that takes place between judges, that this is how one should do, or this will have this implication, then they can settle somewhere else.
My lord, I have not had.
Yes, that's
इसका डिस्क्लोजर किस हद तक करना चाहिए नहीं करना चाहिए ये तो पर्सन वेरी
नहीं देखिए, I think this sort of dialogue at least hasn't ever happened with myself. What you, once it is ascertained, there are two aspects to a criminal trial: guilt or not guilt. And if there is guilt, then comes a punishment. How much? In matters of punishment, of course, you can discuss. Yes, this case is so horrendous, maximum punishment, or not really. It could be in a theft case. There are all these things have variations. You can see whether it's CNS, whether you have drugs. In matter of murder, there are only two punishments: life or death. So yes, but the negotiation aspect could be, or the discussion aspect could be on the part of either you try to persuade each other that their other person is guilty or not guilty. But the other negotiation can only be on the matter of the punishment part. And it's always, generally the settled rule is that even if one is inclined towards lesser punishment, you go with that view. I mean, I don't know, that's kind of, I think that's the approach. Even in bail matters, that if three judges, one thinks that's a bailable matter, then you go with that view rather than reject it by a majority. I don't know. I thought these are the principles we have evolved. What is your opinion?
Sir, जो Indian law में
नहीं आपका opinion बताएं.
In my opinion, the verdict should be unanimous in case of death. If the verdict as to guilt is not unanimous, then death sentence should not be awarded because you can never bring back a life.
और ये जो डिस्कशन आपने पढ़ी है उससे भी यही लगता है कि सब उस पर शायद एग्री नहीं थे कि इट इज ए केस ऑफ कैपिटल सेंटेंस.
सर, पनिशमेंट के ऊपर permissible, technically speaking at least, and bowing to what Justice Mansoor Ali Shah has also said, but technically speaking, at least the only points of negotiation could have been how heinous was the case, whether what was the past track record of the accused, so and so, etc. Those were the only permissible judicial considerations. The political impact of it, strictly speaking, is a non-judicial consideration. It is an extraneous judicial consideration. I do, of course, although the traditional saying is let justice justice be done, but the heaven even though the heavens fall. But I do realize that sometimes practical considerations are discussed.
But I'm sure you've read books from American judges who talk about, they go out for lunch together, they try to convince each other, there's a lot of dialogue going on, they very openly write about it in their books. So, and then it could settle elsewhere, it could settle somewhere else.
Fair enough, I'll move on to my next point, sir. The interview, sir. Sir, ये interview का अगर आप page 7, type page 7, interview is at tab 20. And इसका type page 7 जो है, that is $655. Itself is a little vague. I'll point out from the beginning. What it does say is that the relevant bit is मिडल ऑफ द पेज, इफ्तिखार अहमद सर, ये भुट्टो का, जुल्फिकार अली भुट्टो का हिस्टोरिकल केस है। मैं जर्नल
ये पेज कौन सा है?
655
जी।
जर्नल असर अंदाज हुए थे, दैट इज इफ्तिखार अहमद क्वेश्चन, एंड देन जस्टिस शाह आंसर्स, नहीं मेरा नहीं ख्याल असर अंदाज, हमें तो किसी ने नहीं कहा कि इस तरह फैसला करो उस तरह फैसला ना करो, हो सकता है, एंड दिस इज दैट इज हो सकता है चीफ जस्टिस से वो बात करते हो और थोड़ा बहुत इनडायरेक्टली हमसे कहते हो कि इस तरह कर लिया जाए तो बेहतर है।
इसका क्या मतलब है? इनडायरेक्ट मतलब, हाँ?
This is, I'm just pointing out, I'm not...
What do you understand by it?
My lord, the implication is that nobody talked to me, they might have been talking to the Chief Justice who indirectly conveyed it to me. But that is an implication I'm not going to draw.
आगे भी पढ़ने जरा।
जी सर।
लेकिन मैं 26 साल से ये भी पढ़ते हूँ।
लेकिन मैं 26 साल सुपीरियर कोर्ट का जज रहा हूँ, मुझे एक दफा भी याद नहीं कि कभी किसी ने हमें कहा हो फैसला इस तरह करो, इस तरह ना करो। ये जज जो हैं वो खुद ही डर जाते हैं कि हमने पता नहीं जमीनें ली हैं, जमीनें ली हुई हैं, हमारा बेटा मुलाजिम है, हमारा यानी अब कॉन्फर्मेशन का मसला आ रहा है, तो हमें फौजियों को नाराज नहीं करना चाहिए।
जनरलाइज
बाकियों के बारे में
जनरलाइज बात है, जनरलाइज बात
हम क्या बात कर रहे हो?
but he speaks specifically about the Chief Justice, at least in vague terms, but I'm not. The more important
it is vague and you are referring next time इसकी कमेंट्री आप बना के।
सर दूसरा पेज जो इम्पोर्टेंट है, अगर आप पेज 8 टाइप पेज 8, दिस इज द नेक्स्ट पेज सर।
पेज क्या है
सर? पेज 656 और इसका अबाउट द 10th लाइन फ्रॉम द बॉटम। तो साहब ये जो, जब मैं अगर मैं मुजरिम हूँ, मैं अक्यूज्ड हूँ, मैं कहूँ कि मुझे आप पे एतबार नहीं, मुझे आपसे इंसाफ की तवक्को नहीं है, तो आप बतौर जज क्या करना चाहिए? नाउ इसमें फिर देन ही गोज डाउन द सेकंड लास्ट क्वेश्चन, इफ्तिखार अहमद, मौलवी मुश्ताक साहब की मैं बात कर रहा हूं। मौलवी मुश्ताक साहब को जुल्फिकार अली भुट्टो ने ये कहा। जस्टिस नसीम हसन शाह, जी हां, और मेरे ख्याल में मौलवी साहिब की ज्यादती थी, क्योंकि वो बहुत यानी जबरदस्त आदमी थे और वो भुट्टो के दुश्मन थे और उनको चाहिए था कि वो उस केस में ना बैठें तो बेहतर था। Now, if this was his view that Justice Maulvi Mushtaq was the enemy of Zulfikar Ali Bhutto, in that case again, while sitting on the bench in the Supreme Court, he should have come to a different conclusion.
ख्यालात का इजहार तो उनको अपने जजमेंट में करना चाहिए था, नोट कर लिखते उसमें।
बिल्कुल।
लेकिन उन्होंने कहा कि जजेस जरा वो उस वजह से, कुछ जरा की वजह से रह गए, नहीं कहा।
नेक्स्ट बिट सर, ये पेज 9 है, टाइप पेज 9, 657 पे।
मिटिगेटिंग सर्कमस्टांसेस पे आर्गुमेंट का भी लिखा हुआ है कि
जी जी उस पे ही आ रहा हूं सर, मिटिगेटिंग सर्कमस्टांसेस पे जी।
कहां से पढ़ना?
जी सर, फ्रॉम द टॉप। सर आपने एक जगह पर अपनी राय का इजहार किया। आपने कहा कि भुट्टो के केस की समाअत के दौरान मेरी यानी आपकी जाती राय थी कि भुट्टो की सजा में कमी हो सकती है। जस्टिस नसीम हसन शाह, जी, और इस सिलसिले में उनका केस बड़ा मजबूत था। हाँ बिल्कुल, सो ही कंसीड्स दैट as far as that was concerned his case was very strong. फिर आगे सर इफ्तिखार अहमद आस, तो जज साहब, जब आप कन्विंस थे जो आप फैसला दे रहे थे, तो डिसेंटिंग नोट नहीं आपको लिखना चाहिए था? इस हद तक कि सजा ना दी जाए। जी हाँ, हो तो सकता था, मगर जब वो जो उनका वकील है वो कहता है मुझे सजा की कोई परवाह नहीं, मुझे तो एक्विटल चाहिए, तो चाहिए। मैं समझता हूं भुट्टो यानी जो है वो, सर आप भी डिसेंटिंग नोट तो दे सकते थे, जस्टिस नसीम हसन शाह दे तो सकता था, मगर यानी मेरे ख्याल में इसमें कुछ थोड़ी सी हमारी भी कमजोरी थी और कुछ उसकी याया बख्तियार की भी थी, यानी जिद। उसने हमें एक किस्म का नाराज कर दिया। Now, one, he is conceding to weakness in not dissenting. The second, he is attributing it to the annoyance created by the counsel for the accused. Now, obviously, that is something, and particularly in a death sentence case, whether the counsel of the accused is annoying or not, what he argues or what he does not argue, the judge has to apply the law and the facts on the record.
The litigant should not be punished because of conduct of the lawyer. I mean, that's basic, and even in every civil case, I mean, you may be faced with an obnoxious, let's say, counsel, but that doesn't mean that the litigant should suffer as a consequence.
And in a death sentence case, sir.
अगर वो annoyed
In any case, I would say.
In any case.
अगर वो annoyed ना होते तो ये दूसरी तरफ चले जाते और
शायद
कुछ और
उम्र कैद की सजा हो।
उम्र नहीं बल्कि acquittal
तो कह रहे हैं acquittal भी हो सकता था।
Acquittal भी हो सकता।
लेकिन ये बात बिल्कुल गलत कह रहे हो कि उन्होंने आर्गू नहीं किया। ये 1979 की देखें 807 पे 174 पेज पे स्पेसिफिकली लिखा हुआ है कि ये बख्तियार ने ये आर्गू किया कि ये मिटिगेटिंग का केस है।
ये कौन सा पेज 174 सर?
जी जी नहीं, पेज है 807 पैरा 174
जी,
जरा पढ़िए उसको। अगर ये बात वो गलत लिख रहे हैं तो क्या गारंटी है कि जो कुछ बाकी कुछ फरमाया इन्होंने वो भी सही होगा?
ये कमिश्नर पिंडी वाली इंटरव्यू लग रही है।
हम उसमें देख लेते हैं।
807 पे आइए ना।
सर, does your lordship have the SCMR की citation या Supreme Court की? I have PLD 79,
PLD 79,
Supreme Court 53,
Supreme Court 807 पे आइए ना। 807 पे आइए।
सर ये मेरे पास, I'm sorry जी, ओके
807 174 पढ़िए।
जी जी, ये शायद बात ये रिव्यू वाली जजमेंट है।
174 पढ़िए ना।
174. We may now deal with the last submission made by Mr. Yahya Bakhtiyar that in any case, even if the conviction of the petitioner is maintained, it is a fit case where lesser penalty should be awarded for the offence falling under section 302 of the PPC, read with sections 109 and 111. Thereof, for the reasons that the petitioner is guilty only of abetment and was not present at the spot at the time of the murder, that the conspiracy was to kill Ahmad Raza Kasuri and not his father who was hit by accident, that the conviction of the petitioner is based on the evidence of approvers. There has arisen a difference of opinion between the learned judges of this court as to the petitioner's guilt, that with the introduction of Islamic laws in country with effect from 12th Rabiul Awwal, it would be anomalous to impose death penalty for unintentional murder, especially when Shariat laws do not recognize an approver, and the witnesses have to fulfill strict qualifications as to integrity and character before the testimony can be acted upon, and that the fact that the petitioner was compelled to boycott the proceedings in the trial has also a bearing on the question of sentence. Now, 175
जो कुछ भी यहिया बख्तियार ने कहा, ये सेटल्ड प्रिंसिपल है मिटिगेशन के लिए, हमेशा कंसिडर किए जाते हैं फौजदारी लॉ में। कभी भी ऐसा हो तो हमेशा कंसिडर किए जाते हैं। तो ये तो थे, तो वो जो जैसा फरमा रहे हैं कि किसी ने आर्गू ही नहीं किया।
सर, अगर आप अगला पैरा पढ़ लें 175,
पैरा 175 में
जी, we find that none of these questions was raised by the learned counsel during hearing of the appeal. Although all these factors,
he's not required to even.
कहाँ required है यार?
सर तो उन्होंने ड्यूरिंग द मेन अपील आर्ग्यू नहीं किया था जिससे जजेस की तरफ से कुछ नाराजगी हुई।
वो पॉइंट तो रिव्यू में भी लिया जा सकता था, ये कोई ऐसा इश्यू नहीं था।
थोड़ी हमारी भी कमजोरी थी लिखा हुआ
ऐसा पनिशमेंट का तो इश्यू नहीं।
Now, my lord, the question was raised about the weight that is to be given to Justice Shah's revelations. I had already pointed out and it's the citations are also there, para 9 of my statement.
रिटायरमेंट के कितने दिन बाद किताब लिखी थी उन्होंने?
Sir, 2002 में तो it is probably about 10 years.
This interview is
about 10 years. जी.
हमारे सारे लोगों को रिटायरमेंट के बाद इनका ज़मीर जागता है वो कुछ कुछ कहना शुरू करते हैं, पहले तो कुछ नहीं कहते।
सर
अब इनके दो स्टेटमेंट्स आगे दो, एक तरफ जजमेंट है दूसरी तरफ बुक है, तो किस पे रिलाई करें?
Sir, I am not saying that his book should also be relied upon. I am saying that his book has raised a reasonable possibility in the minds of a neutral observer.
To the extent that he condemns himself.
Yes, to the extent that he condemns himself, not anyone else. Now, jahan tak weightage to be attached to a book for these kind of statements is, my submission which I had made was that as per Article 46, 1 and 3, even in a trial, these would be admissible against Justice Shah. But in these proceedings, this court does not have to apply the standard of a trial. A somewhat similar situation arose, if your lordship will recall, in the dissolution of assembly cases. Over there, the question was that there were certain newspaper reports, etc., that was thought to be relied upon.
Which period are you talking about?
Sir, jo 90s ke dissolution of assembly ke cases the. And lastly, in Benazir Bhutto versus Federation of Pakistan, PLD 1998, Supreme Court, page 388.
Gee, what was the point you're making?
The point that was, the distinction that was drawn there was that these newspaper reports are not being relied upon as per the absolute truth or otherwise of these reports, as would be done in a criminal case.
There's also a judgment that unless denied by the other party, these are the admissible.
जी बिल्कुल बिल्कुल उसमें distinction ये draw की थी that over here we are merely gauging whether the president has reasonably formed his opinion under Article 58(2)(b). And the president is required only to, he is not required to form an opinion on the basis of strictly proved evidence as required by law, but as a person of ordinary prudence would conclude. So if a person of ordinary prudence would conclude these newspaper reports which had gone unrebutted, that reliance could be placed upon them, so the president was justified in reaching that conclusion. Now over here, your lordship is required to put yourselves not in the place of a reasonable president, but a reasonable observer. And if the reasonable observer would use the book and the interview of Justice Shah to reach conclusions about the fairness of Justice Shah in the trial, in the appeal, then that is enough.
And render the opinion on this.
Yes.
We can discuss the conduct of Mr. Shah.
You keep on saying Justice Shah and it gets me worried.
Sorry, sir?
You keep on saying Justice Shah.
I'm sorry, sir.
I'm sure it was intentional.
No, I was very worried, sir. At one point, I had said Yahya Afridi instead of Yahya Bakhtiar, and I apologize for that also, I realized later.
I had missed that. Gee.
Now, sir, given that any opinion of this court...
sorry to interrupt you. I'm seeing the original file, and this is the application of review filed by Mr. Hafiz Pirzada. I'll just read this paragraph. I don't know if he made a mistake or it's so, that the remainder of the appeal bench comprised of 5 permanent judges of the Supreme Court, 1 ad hoc judge, namely Mr. Justice Wahiduddin Ahmed, appointed after his retirement under Article 182, and 2 judges of the High Court of Lahore, appointed temporarily on ad hoc basis under Article 181, 182 of the Constitution. Who were the 2 Lahore ones?
Lord Justice Naseem Hassan Shah.
So they were temporarily from the Lahore High Court.
This is in the PLD.
PLD 78 Supreme Court का जो है उसमें mention हुए नाम mention किए हुए जजेस.
मगर वो ad hoc थे वो.
अच्छा एक और point जो which I have read, which I just want to read out. Paragraph 9 from this application. That after the judgment was reserved, 2 developments of vital and grave import concern to the petitioner occurred. The first being that the Honorable Chief Justice was once again called upon to temporarily act as the President of Pakistan, and in that capacity delivered an address highly commending the bona fide and determined efforts of the present government to introduce Islamic order in the country, and in contradiction deprecated the failure in this regard of the previous governments. The remarks of the learned Chief Justice evoked a very strong protest from the leaders of the Pakistan People's Party and the wife of the petitioner, who by a letter dated 30th December 1978 requested the Honorable Chief Justice not to write the judgment and to dissociate himself from the appeal. But this aspect was not considered in the order that I have been able to see. These 2 points which have been taken in the review petition, rather the latter one, which the Chief Justice is commenting on very strongly on. I don't know if it has been or not.
Sir, agar aap 1979 SCMR 271 देखेंगे. 1979 SCMR 271. To show what? सर उसमें एक ऑब्जेक्शन, एक एप्लीकेशन फाइल की गई थी अगेंस्ट जस्टिस अनवारुल हक्स बायस, वो रिजेक्ट की गई थी. बट दिस डज नॉट डील विद द एस्पेक्ट दैट योर लॉर्डशिप हैज पॉइंटेड आउट.
Who has decided the application?
Sir, this is by the full bench.
No, the author
Full
of
court.
the judge.
All 9 judges, sir, वो उसमें तस्करा नहीं है उसमें.
नहीं लिखा हुआ है.
Anwar, sorry, just Chief Justice Anwarul Haq. Sorry, sir. But it is an order of the court. There was a previous application that was also dismissed, जो बहुत detailed थी.
ये जो जिस application का मैंने अभी जिक्र किया आपसे, this application, since you don't have the file, is 19th of February 1979, and this application that is being attended to in this order is 3rd of July 1978. So I presume it's some other application.
It is some other application.
So ठीक है. तो इसका कुछ पता है आपको क्या बना?
I do not know.
About this fact that he became president of Pakistan?
I do not know. But I do know that he did become president of Pakistan.
इत्ज़ा साहब को जरूर पता होगा ना, या रजा रबानी साहब को पता होगा ये history. Did he become president of Pakistan, the Chief Justice, acting president? Huh?
Several times, not just the one quoted here, because this was during the trial that he became, while he was earlier on, when the matter was before the High Court also. Mr. Justice Anwarul Haq, you can get the log, I am sure.
ये अगर आप ये जरा
एक्टिंग चीफ
रजा रबानी साहब को ये फाइल
सर,
दे
ये
दें.
प्रेसिडेंट वाला मामला पहले भी उठा था.
ये उनको बोले 2 मार्क चीजें जरा पढ़ लें, मगर फाइल वापस जरूर ले लीजिएगा जी.
ये PLD 1978 सुप्रीम कोर्ट 125 में भी यही ऑब्जेक्शन उठाया गया था.
1978
सुप्रीम कोर्ट 125. ये इन चेंबर एक ऑब्जेक्शन की गई थी, वो उन्होंने अकेले सुन के उस पे फैसला किया था. इसमें अगर आप पेज 131,
here it was a very standalone thing that as president you commented upon something.
जी.
So how many objections were taken? 1, 2, 2 तो हमारे पास reported हैं. और ये जो application का जो फैसला है, रज़ा रब्बानी साहब, there are 2 tabs that I put. One is the application, 16R I think is the number, and the other one is the decision on that. But I didn't see this aspect of the case being attended to in that application. ये जरा देख लीजिएगा the Chief Justices, because at the moment we are only concerned with the prejudice of one of the learned judges, the ad hoc judge. But here is prejudice of the Chief Justice. ये जरा just have a look at these. Ji, sorry.
जी sir. So just pointing out कि ये.
How long will you take?
I'm just wrapping up, sir.
Okay.
Now, given that the opinion of this court shall not disturb the finality of the judgment, and because with the proposal that I have put before your lordships, it will not have the effect of opening the floodgates either, because of the limited exercise your lordships will be doing. The question does arise whether just by giving an opinion, would it amount to basically an exercise in futility? Now, I would submit that it will not.
That is not for us to consider. If the President deems it fit to ask us a question, we'll answer it. Whether it's an exercise of futility or not, what difference it will make?
Bilkul. That is the.
Unless I'm missing something.
That is the position. It is no one's case that someone wants to file a suit for malicious prosecution or.
It's not an ordinary person. It's a president. It is a president, and he's been given a role in the Constitution. Whether he should have or not, I mean, that's another debate. That's his domain. Ji.
Is there any material on the bias in law, the objective part, because this could also pass for a question of fact, this particular interviews and all this, but you're saying no because bias in law, this is a legal question.
Yes.
So any material to support that?
जी sir, वो मैंने in the note, the footnotes.
It's in the footnote?
जी, ये पेज 6 में जो footnotes हैं, उसके मैंने tabs भी बनाए हुए हैं. They deal with this. Now, finally, sir, as your lordship, the Honorable Chief Justice has pointed out, right now your lordships are confronted with only a reference. Now, the other underlying question, which perhaps in appropriate jurisdiction will need to be answered, is that how to balance a case of miscarriage of justice with finality of adjudication. How other courts have done it. Mr. Makhdoom Ali Khan had referred to Pinochet की judgment, जिसमें उन्होंने inherent jurisdiction invoke की. उसी तरह एक और judgment है जो मैंने cite की है, Taylor versus Lawrence. वहाँ United States में 2 तरीके करते हैं courts. या तो एक वो quorum nobis की writ या दूसरा habeas corpus की. वहाँ उन्होंने habeas corpus को expand किया है कि they say कि it doesn't merely mean that before some FIR is shown, it also means that if someone has been unlawfully convicted and there is a fundamental miscarriage of justice, then using habeas corpus we can free them. Then there are of course the statutory remedies. I have detailed some of them in my note, where statutory bodies for review, and because often sir, nowadays especially with DNA, new evidence comes to light which completely, and there is no scope. हमारे civil law में section 12(2) है, मगर equivalent counterpart criminal law में immediately nahi hai. So, but these are aspects for the parliament to consider, and perhaps in a judicatory jurisdiction your lordship might see to what extent your lordship can deal with that. Over here an opinion would be sufficient.
561A है वो
जी, वो 561A पे सर वो ये है कि आया उसको वो दोबारा खोल सकते हैं as a review exercise, उस पे debate है सर. So it is not clear.
It's been a pleasure hearing you, and you've been very thorough. And we'll certainly read your note and go through the points.
I'm grateful for the privilege, sir.
Let's conclude today's things, and tomorrow we will keep for, I think on the last date of hearing we had kept for yourself and Mr. Khalid Javed Khan, and both of you, Khalid Sahab, thank you for your assistance. and tomorrow we will hear the criminal aspect of it. Mr. Manzoor Malik and Mr. Asadullah Khan Chamkhani Saab said he's already submitted a written brief, so if required we'll ask him questions. And tomorrow we'll start with Mr. Manzoor Malik.
I would like to address briefly on some aspects.
ठीक है. After Mr. Manzoor Malik, because आपने कहा you are not appearing, Mr. Raza Rabbani is appearing.
सर इसमें आपने आई एम अपियरिंग फॉर बिलावल साहब, आपने हमको जरा सुन ले, फिर इसके कहते हैं क्रिमिनल पर आइएगा. आई वुड रिक्वेस्ट दैट.
नहीं, काफी इस बात पे सुन लिए, जरा सब टोटलिटी भी देख लें. आपको डोंट वरी, आपको दूसरी बात का भी एंजाइटी है ना, वो फिर आप ये ना हो वही वाली बात हमारे साथ हो जाए.
नहीं.
So नहीं, इंशाल्लाह we'll try to again today we made ground. And we'll try to we will try to keep our questions and interruptions at a minimum.
There are certain videos which I would like that the court should hear.
We will certainly hear.
वो अभी तक आपने सुनी नहीं है.
We will certainly hear them. And if required tomorrow, कल हम चला भी लेंगे.
जी हाँ.
But let's this dimension has been thrashed enough. We wanted to now see the other dimension of the case, the total picture that emerges, and then you can maybe during the things, if it's relevant, we'll put it up. कल का इंतजाम कर लीजिए, अगर वीडियो चलाने के.
कल ये सारी वीडियोज आप सुन लें तो बड़ा क्या कहते हैं क्लैरिटी आ जाएगी आपकी.
उनके बाद देखें वो आ रहे हैं तो जरा उनको खत्म कर लें, फिर आप तो
चले उनके बाद फिर हमें क्या मंजूर मलिक साहब के बाद
we will just see how it goes. I don't know. कल एतजाज साहब को भी सुन लेंगे. अगर सिर्फ बता दीजिए आप किसको रिप्रेजेंट कर रहे हैं.
I'm an amicus. I was appointed amicus on the.
Why have you not been coming?
सर मैं
वो खत्म नहीं कर दिया सर.
आप आए नहीं पहले
वाली लिस्ट में थे ना जो ओरिजिनल.
चलें खैर.
So there was a statement.
आपको कोई इतराज है? but I don't know किसी को, because हम देखें इतराज साहब हमने लास्ट टाइम कुछ लोग अमाइकस पे इतराज था, हम लोगों ने उनको नहीं रखा. अगर if anybody has any objection say so, otherwise we'll hear Mr.
There was a statement made regarding you that इसने कोई ऑर्डर शीट में लिखा. ऑर्डर शीट जूनियर पेश हुए थे मेरा ख्याल.
What was the statement?
We'll just there's a order sheet. Let's have a look. पहले वो order sheet.
ये था कि इन्होंने कोई रिप्रेजेंट कर लिया.
इनका नहीं था, इनको जूनियर पेश हुए का
Because your name was mentioned on that day.
2-3 ऑर्डर दिए हैं, ऑर्डर शीट देख. वो एक मिसपरसेप्शन थी कि I was in the
Somebody made a statement at the bar.
interim. That is right. In the interim, I was instructed by the president, Mr. Zardari, and since Mr. Naik and the Attorney General.
No, I had nothing to do with the president. I filed an impleadment application on behalf of Bilawal Bhutto Zardari. I had nothing to do with the president of Pakistan.
ये सब की बात मुझे भी कुछ याद आ रही ऐसी बात हुई थी.
कल देख लेंगे.
And I thought it. I want to clear this.
We'll do it tomorrow. So देख के फिर कल कर.
ऐसा करें आप जरा ऑर्डर शीट देख लीजिए.
जी सर.
अगर कोई ऐसी बात ना हुई और अगर
शीट में नहीं है सर.
बस फिर ठीक है. फिर हम देखते हैं कल.
ऑर्डर शीट
चलें. थैंक यू वेरी मच. टुमारो सेम टाइम 11:30. आज का लिख दें और शॉर्ट ऑर्डर है. लर्नड MIC Mr. Khalid Javed Khan and Mr. Salahuddin Ahmed have concluded their submissions. They have respectively filed CMA number so and so to come up tomorrow at 11:30 a.m.